Wait, wait.
Hmm.
So for the item number 19 to 31, my lord. Based on my lord, regarding my lord, dismissal of the appeal, which is connected with the eviction initiated by the railway authority, my lord. And if you lordship take note, the one item number 31, I can my lord explain all the what happened in. My lord, so far, eviction process initiated by the railway authority is concerned, my lord. The petitioners, all the petitioners earlier approached this honorable court in relation to
Okay,
the process-
anybody for
Rail.
Union of India? Who will appear? Okay, Gogoi. Where is Mr. Gogoi? Okay, Mr. Sama, wait for some time.
Item 4, orders. Item number 5.
The matter may come up for admission since services complete.
Service completed.
Yes, sir.
Heard Ms. Bora, learned counsel for the petitioner, and Mr. Ghosh for the respondent. Since service in this matter is completed, recessal is the matter for admission hearing. After 1 week or 2 weeks?
2 weeks. 2 weeks, Lordship.
After 2 weeks.
Lordship.
On 12th August.
Lordship. Deeply opposed.
Item numbers 6 to 8.
In the order review, 10 to 2025, amendment number 27 of 2016.
Hmm.
So I filed my counter review with raising objection. This one mentioned.
Hmm.
As per their petition, they are claiming their matter further.
Okay. Okay.
Lordship, matter may be fixed after 2 weeks, Lordship.
Why?
Lordship, similar matter squarely covered by this order is squarely covered with another appeal in MFA 44 by 2024.
Hmm.
Is judgment CAV dated 18/6/2026 by Honorable Justice Mridul Kumar Kolita, sir.
Hmm.
Lordship, after 2 weeks, that may be fixed.
After 2 weeks.
Lordship.
Okay. Heard Miss
M. Kolita.
learned counsel for the petitioner, and Madam U. Chakraborty, learned counsel for the respondent. On the pair being made by Ms. Kolita, learned counsel for the petitioner, this matter stands adjourned to be listed after 2 weeks.
Oblige your Lordship.
Correct.
On 21st August.
Okay, oblige your Lordship.
Item 9.
This is come for orders, my lord. Your opinion?
Yeah, service completed.
My lord, I think
Service completed.
private respondents, my lord, she is representing.
You are for respondent number
1 to 10, your Lordship.
1 to
1 to 10.
1 to 10.
11 to 11-12 also, my lord, because 11-12 are, my lord, representatives of respondent number 3. No, Habib Ali. Uh, 11 and 12.
Heard Mr. Gupta, learned counsel for the petitioner. Miss, your name, please?
Sangeeta.
Yes.
Sangeeta.
Sangeeta, Learned Counsel for the respondent. Number 1 to 10. Office note dated 28/7/2026 indicates that notice issued to the respondent number 11 and 12 returned unserved with a report insufficient address RTS. Said office note also indicates that neither ID card nor unserved notice issued to the respondent number 13 to 22 2022 returned till date. Learned Counsel for the petitioner is directed to take fresh step upon respondent number 11 and 12 by obtaining necessary instruction in respect of the correct address within a period of 2 working days from today. List the matter after 4 weeks awaiting service report upon respondent number 13 to 2022.
So the interim order will continue.
Interim order passerly shall continue. None appears for the petitioner on call. List the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Item 32.
None appears for the petitioner on call. However, Mr. Your name?
M. Malaka.
M. Malakar, Learned Counsel for the respondent present. In the event of subsequent non-representation of the petitioner, appropriate order shall follow. Recess shall list the matter after 1 week.
Item 33.
May it please your lordship, condonation application for the first time, but notice may be issued. But already in another RSA connected matter, lordship, out of the same judgment, we have filed 2 regular second appeal. In another IA lordship, notice was issued on 15/7, fixing next date 17/8.
17?
8, lordship.
Okay. We will fix this matter on that day.
Yes, lordship. And this matter may be listed along with IA civil number 1708 of 2026. Sorry, lordship, next date is 21/8.
21/8.
21.
What is the number?
IA civil number 1708/2026.
1700 A
1708.
08. Ms. R. Soduri, Learned Senior Counsel, assisted by Ms. So Learned Counsel for the applicant. This application under Order 41, Rule 3A of the Code of Civil Procedure, read Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 18 days in preparing connected regular second appeal against the judgment and decree dated 22nd of December 2025 passed by the Learned Civil Judge Junior Division Boygaon in TA number Senior Division, not Junior Division, Boygaon in TA number 02 of 2022. Let notice be issued to the respondent. No, opposite party returnable on 21st of August 2026. Step be taken by speed post and also by usual process within a week from today. Ms. Soduri, Learned Counsel for the applicant, further submits that against the same impugned judgment and decree, another regular second appeal is being filed, is preferred before this court. And there also one interlocutory application being IA civil number 1708 of 2026 has been filed. And the said case has been, said interlocutory application is fixed on 21st of August 2026. And as such, this matter may be tagged with the IA civil number so and so. Where allowed, recess shall list the matter along with IA civil number.
Lordship, in this case, notice to be issued to respondent number 1 to 4. 5 has already filed a caveat, lordship. Caveat number is 1820.
Caveat is not placed before the court. Is it
The
there?
cause list shows the number of caveat, lordship. 1820 of 2020.
Record is not available before the court.
Lordship. Obliged.
For admission. Appeal number 1.
May I please, your lordship? My lord, a suit was filed for declaration and partition in the year 2012, being titled suit number 95 of 2012, my lord. And that was decreed on 25/4/2024. The decree was made on 4/5/2024, and as against which, my lord, I being the defendant filed an appeal, but my lord, with a delay of 170 days delay. 117 days delay. When the notices of that delay application was sent, then the process server reported that performer respondent number 10 and 12 and 13, they have expired long back. That is some 3 to 4 years back. That is before the passing of the decree. And then I filed an application before the learned First Appellate Court, my lord, under Order 1, Rule 10(2), to delete their name, strike out their name, because they never contested it. My lord, as against that, an order was passed on 30th of July 2025, which your lordship will be pleased to find at page number 49. Page number 49. But one thing I would like to mention here, my lord, that the suit was for declaration of Schedule B property. Issue was also framed, but no preliminary decree was passed. That I am simply submitting, my lord. It is in the case, but that why I am submitting that, my lord, because the decree was bad in that way, and even the judgment was bad. That's why it was challenged. Only default in me is, my lord, 170 days.
You tell me when the judgment and decree was passed?
The decree was passed on 4/5/24, my lord.
4/5/2024.
Yes, and the judgment was on
those are respondents. Who
My lord.
died?
My lord.
Who died?
Performer respondent number 10, 11, 12 and 13. They never contested the suit also, my lord, because they were the vendors. Vendor of me.
Mr. Sutter, you say
Yes.
this decree was passed against dead person.
Yes.
It is a nullity.
It's a nullity. So, my lord, was it my responsibility? I'm just submitting before your lordship. Being the defendant, was it my responsibility to substitute his heirs, or it was the responsibility of the plaintiff, who at that time was contesting the case for partition 5 years back? So that's why, so far this order is concerned, my lord, 37/2025 order itself is bad. Wherein the learned First Appellate Court has directed me to amend the appeal, whereas, my lord, the appeal is not admitted because of the reason that delay condonation application is pending to condone the delay of 170 days. If your lordship permits me to take to this page, I can take.
No, you say the judgment against whose appeal has been preferred. Judgment and decree against whose appeal was preferred.
Yes, title appeal 72/24.
Yes.
But with a delay of
No, that's all right. That
Yes.
decree itself is a nullity. It's a nullity.
Yes.
As it is against dead person.
As against a dead person, and as against also that, my lord, their partition was sought for. There was no compliance of Order 18, Order 12, Order 20, Rule 18, no preliminary decree, no final decree.
You suggest the way out then?
My lord, in this substitution application, I have tried to strike out the name of respondent number 10, 12 and 13, and one
decree has already been passed.
Yes.
After passing the decree, can it be done?
After passing the decree, it cannot be done. It cannot be done. No doubt, my lord. But they never contested the suit.
No, contested
never
or not
contested
contested,
performance.
that is a different matter.
Yes.
contested or not contested, that is a different aspect. But they are dead.
They are dead. They are dead, and as per, in my respectful submission before your lordship, as per order 22, rule 12,
Hmm.
their name cannot be substituted also in the execution proceeding.
Hmm. Hmm.
So unless this order is set aside, that condonation application is heard, and delay if condoned, then the appeal will be heard, appeal will be registered and it will be heard. They never filed any objection also before the learned trial court. Now my learned friend has come before your lordship, perhaps to object, but to what to object, I don't know. If I can take your lordship to that impugn order.
Hmm.
It is, my lord, at page number 49.
Hmm.
May I read, my lord?
Hmm.
Petitioner and opposite parties are represented by learned engaged counsels. Instant order arises out of petition number 421/25 filed by the petitioners appellant under order 1 rule 10(2), read with section 151 of the CPC. The petitioners have stated that they preferred the connecting appeal against the judgment and decree dated 25/4/2024 entitled suit number 95/12. The petitioners also submitted petition under section 5 of the Limitation Act, praying for condoning of delay of 170 days in filing the appeal. Ms. J case number 159/24 was registered on the basis of the said petition, and the court directed the petitioners to take steps for notice. The respondents as a plaintiff filed the present suit by aiding all the co-patadars as pro forma defendants. Thus, while preparing the appeal also, the appellant made party to the appeal as pro forma defendants. Accordingly, the appellant took steps for notice upon the pro forma defendants. However, notice on pro forma respondent number 10 returned unserved, and on inquiry, the petitioner came to know that pro forma respondent number 10 died before filing of this appeal, leaving behind him the opposite party respondents. They are already there. Hence, it is necessary to strike out the name of pro forma respondent number 10 from this appeal. From the report of the process server, the appellants also came to know that respondent number 12 and 13 had died before filing of the instant appeal, leaving behind them Kustav Das as their only legal heirs. Thus, it is necessary to strike out the names of pro forma respondent number 12 and 13 and to add their legal heirs, Kustav Das, in the instant appeal. The opposite parties have not submitted any written objection on the instant petition. The petitioner has stated that pro forma respondent number 10 died before filing the appeal. Regarding addition of the legal heirs of pro forma respondent number 12 and 13, the petitioner has stated that they came to know about their death from the report of process server. The report of process server dated 27/12/2024 shows that pro forma respondent number 12 died about 5 years ago. This is most important part which I wanted to place before your lordship, that when the suit was pending, at that time these pro forma respondents were died. And it was the bounden duty on the part of the plaintiff petitioner to include them or their heirs as a party. It was not done 5 years ago. And pro forma respondent number 13 died about 6 months ago. From the petition itself, it appears that the appeal was filed against dead person, that is pro forma respondent number 10, 12, and 13. The Honorable Court, in the case of Gurcharan Singh versus Surjit Singh and another, while deciding a matter relating to substitution, it is substitution stated as follows. Thus, the aforesaid authorities are clear that where a party has been impleaded as respondent in an appeal, but such respondent was dead before filing of the appeal, the remedy of the appellant is not to file an application for substitution of legal representative of such respondent, but to file an application for an amendment of the appeal memorandum, and in case where such application is filed, beyond the limitation prescribed for filing the appeal, the appellant must also file an application under Section 5 of the Limitation Act for condonation of delay in filing the application for amendment, and if the court is satisfied with the explanation given by the appellant for the delay, the court can condone the delay and allow the amendment of the appeal memorandum. Thus, from the pronouncement of the apex court, that it is clear that instant application for addition to legal heirs or substitution cannot be allowed. Hence, petition is rejected and instant misjudgment case is accordingly disposed of on contest. My lord, I have been directed
So,
by this order.
no, the application was not accompanied by delay condonation petition.
The appeal was accompanied by delay condonation. The appeal was
No, the other application filed by
the other application which was filed, only it is filed on the basis of the process server's report that is on 2710, which is well within time.
one is within time, but the other, this respondent number 12 who died 5 years back.
5 years back, at that time, I was defendant number 1, 2, and 3, and they were the performer respondents. My learned friend's client were the plaintiff. My lord, if they knew that he is already dead 5 years back, at that time he ought to have been substituted in the shoot. In the shoot, not in the appeal.
No, the question is whether it was in their knowledge or not. That is the question.
My lord, they had made them the performer respondent. And we are concerned with when the process server's report came. The process server report came on 27/10/2024, my lord. And I filed the application within 90 days, that miss case. So there was no any need to file any delay condonation application. This is my respectful submission. Furthermore, my lord, the learned First Appellate Court has directed me to amend the memo of appeal, which memo of appeal, my lord, is not yet admitted because of the delay condonation application. And a 117 days delay. This is a situation, my lord, which your lordship can also only solve. Report of the process server is 27/10/2024.
So your submission is that the limitation has to be counted from the date of knowledge
Yes,
or from the date of report of the process server.
process server.
Then it is within the period of
Yes, my lord.
90 days.
90 days. Who reports that they died some 5 years back?
No, there is a recent decision of Supreme Court.
But by this application which I have filed before the learned First Appellate Court, my lord, it was, my lord, it is registered as Miss J case number 49/25 at page number 49. Sorry, my lord, it is at page number 45.
Mr. Alam, what is your submission?
I will calculate it under the same, my lord, on the basis of the judgment of the honorable effect of cutting the same in the judgment, my lord. Wherein, my lord, law is laid down. That in such situation, my lord, memo of appeal is required to be maintained. Have you paid under this application already?
No, unless and until the appeal is admitted for hearing,
My lord.
how
Appeal-
the court can assume jurisdiction? And
No.
appeal can be admitted only after condonation of delay.
So memorandum of appeal, my lord, is connected with condonation application. So they were having liberty to emit a condonation application too, which is in condonation of the appeal. This liberty they were having.
And the limitation period is not 90 days, it is 150 days.
120 days, my lord.
No. 150 days. There is a recent
I said
decision
that,
of,
yes, my lord. Yes, your lordship. Yes, my lord.
But my lord, my simple submission, my lord. In this application, that issue may not be relevant, my lord, because this is the application under order 1, not for substitution.
Not for?
substitution directly. Striking out and adding one.
Because the person who is dead is to be struck out.
And as far as my lord, the concern of the degree holders are the dear my lord. They were not having any knowledge in it.
Hmm.
They were pleaded either to make the proceeded expertise against them.
So, Mr. Sutter, according to you, there is no delay in this matter.
Yes, my lord.
This
50 days, as your lordship have said. My lord, if you can go by the report of the Jarikaran.
what is the date of the report?
27, 12, 24, my lord.
27/12/2024.
24.
And when the application was filed?
My lord, this
21 to
application,
25.
Then it is within the period.
my lord,
My lord, order if it was not passed on the ground of delay. This was not rejected by the type of my lord, the ground of delay.
Hmm.
It was rejected by law on the ground that this is required to be inserted in the memorandum of appeal or connected components application.
which is
No,
not
no.
yet, not yet admitted.
Appeal has been registered.
No, no.
The submitted appeal has been registered as title appeal number 12.
No, registration is something different.
Title appeal 72. Appeal has been registered before the trial appeal court. Title appeal number 72/24.
And what is the ground for delay?
Ground for?
Delay of 170 days?
Yes, that I have already explained, my lord. In Mijje case number 159/2024, which is yet to be heard by the learned first appellate court, my lord.
Major case number?
Mijje case number 159/2024.
Where is the relevant page?
My lord,
Annexure 3.
that application, my lord, I have not annexed along with this one.
So that
That deal.
That is the next.
But it is 159,
Edition 2, page 36, my lord.
yes.
This is condemnation application. Filed in the appeal. Edition 2, page 36.
But it
Delay
is
has been explained, my lord. In paragraph 345.
Paragraph?
345. Page 51, 42, and 42. In paragraph 3, this was a statement that he was the epithet engineer. Thereafter, my lord, he was MLA from Bhagwat constituency. So many odd things happened in his constituency. Get the picture number one. He is having illness and health hazards. Because even lead to his constituency and owing to which various newspapers reported and reflected keywords. Each was showing repercussion in the society. These are the step class.
And he was also hospitalized in GRC, that also in paragraph number 4 I had mentioned at page number 41, my lord.
In paragraph 4, my lord, there is only one date. Regarding attendee, he was attended by Dr. Thomas Das on 26/11/23. When he was admitted, when he was released, nothing is there.
No. Paragraph number 4 is the continuation of paragraph 3, which also speaks, my lord, about the GNRC, wherein 5/6/2024 to 15/11/2024, he was examined by Dr. Habibur Rahman.
No, Mr. Sutter,
My lord.
you see, here the pair was for condonation of delay.
Yes, my lord.
No, the impugn order, is it condonation of delay?
The impugned judgment, my lord, was
No,
On
no, you
20
come to paragraph number 2. Instant order arises out of a petition number 421 of 2025. Filed by the petitioner under Order 1, Rule 10(2), read with Section 151 of the CPC.
yes. This is a separate miss case, my lord.
Hmm.
This is a separate miss case because the learned first appellate court never touched the condonation of delay application and even the memo of appeal. And as this application was filed just to strike out the name of respondent number, I mean the disease respondent.
No, first the court ought to have dealt with the delay condonation application.
Exactly, exactly, my lord. Exactly, my lord. But the direct,
Let us do one thing. We set aside this order. We remand the matter to the trial court. Sorry, first appellate court to first deal with the application under Section 5.
yes,
And if the appeal is admitted for hearing, and only then it will deal with this application.
yes.
We'll pass the order.
Oblige, your worship.
Item number 2.
My lord, the legal proposition is that the decree must follow the footstep of my lord judgment, and that required consideration of this honorable court. Now, lordship, I am just giving the facts of the case in nutshell, my lord.
Hmm.
My lord, what happened, my lord, the Chabua town committee has an old structure, my lord. Now, removing that, my lord, they want to create a new construction over there. Now, this proceeding was initiated from 2014. Now, during that period, my lord, some of the occupants felt that their occupancy may be in threat. Therefore, my lord, in 2014, they filed a title suit. In the title suit, my lord, the basic prayer was that they should not be evicted, and the attempt which has been made by the Chabot Town Committee, that has to be resisted. But my lord, in 2017, between the both party, a compromise has been arrived at. And my lord, that compromise converted into my lord, compromise decree, judgment, my lord. And my the judgment particularly enclosed that the compromise which has been arrived at between the parties has to be implemented. Afterward, my lord, in 2021, my lord, new construction was made, my lord. And out of this new construction, my lord, the person which has been, my lord, the part of that, my lord, trial, they were accommodated. There are 27 numbers of, my lord, occupant. My 22 has already occupied their premises, but the 5 numbers of persons has, my lord, shows their dissatisfaction, my lord. Now, my lord, what happened? The problem now start here for my lord. They have, my lord, obtained a decree, my lord, apply for decree, and decree contain the schedule which is not the part of compromise deed, my lord. Because, my lord, the compromise deed has, my lord, arrived at a certain direction that once new construction be arrived at, based on that, my lord, scheduled property will be handed over to the respective party. But in degree, my lord, it contain the schedule which is the part of the, my lord, the plaintiff, my lord. And based on that, my lord, the education proceeding was initiated. Now, while this education proceeding was initiated, my lord, these 5 persons, my lord, what happened, my lord, their claim was that the schedule which is the part of plaintiff that has to be accommodated to them, my lord. Now, finally, my lord, the trial court below, my lord, in execution proceeding, by virtue of the order dated 27/5/2025, pass an order to evict the decree holder, my lord, on the basis of the prayer made by the another set of decree holder, my lord. Now, against which, my lord, this revision petition we have filed, my lord. Now, lordship, state by lordship, kindly see some of the document I would like to rely upon. First, lordship, kindly see page 30, deed of memorandum of settlement, my lord. Start from.
No, that's all right. Let us go to the impugn order.
My lord, straight.
Page number.
Now, impugn order contained in page 63, my lord. Page 63, my lord. One important line, my lord. Third paragraph. In such a case, it appears that the judgment debtor is not willing to proceed as per the decree of this court, and hence civil nazi is directed to execute the decree. Now, Lordship, we have to see the decree, my lord. Page 39 of the part of decree, my lord.
No, you show me how this impugn order is illegal or
Yes,
it
sir,
is
absolutely. That is the core issue, man, no doubt, my lord. Lordship, the impugn order contains that the decree has to be executed. Now, Lordship, page 39, kindly see what is the decree. Because, my lord, it is a duty cast upon the trial of the execution court to see that the judgment must be, my lord, executed, not beyond it. There is no any alteration, my lord, it's a settled position. Therefore, Lordship, kindly see page 39 in a clear term says about that fact, my lord. Page 39, last. This is the operational part. It is ordered and decreed that the suit is disposed of on being compromised by the party. It's a matter of effect of order 23, my lord. The content of the petition 995-17 dated 27/3/2017 is hereby made part of this decree. The petition marked A and attached herewith for ready references. Therefore, my lord, compromise deed has to be implemented, my lord. Now, Lordship, kindly take a turn, page 40. Now, this schedule, my lord, they have contained, which is the part of plaint, my lord, which were otherwise modified. Now, Lordship, kindly see for a moment what compromise deed contain. The compromise deed, my lord, start from page 30. Operative part in page 33, paragraph 2. Page 33, paragraph 2, my lord. This is the soul of the case, my lord. Married, my lord. That the first parties have agreed to give allotment of shop in the new RCC building to be constructed by Chobo Town Committee under 10% PF for any state to the members of the second party after construction of new shop premises, new market complex, and second party members shall be entitled to get blank shop premises on the ground floor as per the record of the Chabua Town Committee. That means once new construction will take place, my lord, on the basis of that, the allotment has to be given effect to. This is the, my lord, contention of the decree. And, my lord, it has been signed by all parties concerned that contain in, my lord, page 36. All plaintiffs were there. 36. There are 27 numbers of persons there. Out of 22 already allotted, accommodated, 5 shows their dissatisfaction, approach before the trial court by way of execution case. Now they contain the schedule of the earlier market, which does not exist as on today, my lord. Because that was demolished, new construction took place, and based on that, my lord, on the basis of the diagram, proportionate basis, the suitability of that shop, my lord, that was allotted, but they declined to accept, my lord. This is another aspect of the matter. Now, lordship, kindly see execution case. Now, execution, my lord, title execution 2 of 2017, page 45, my lord, start from. Now, this is the form. Out of this, all parties are there, 27 number. Now, lordship, kindly see column 3 contain date of decree, date of judgment dated 27/3/2017. It is nowhere stated the specific schedule to be allotted to them. But the executing court, my lord, travel beyond that, my lord. Column 3 decree, date of decree 27/3/2017. Now, lordship, kindly see column 9, against whom to be executed defendant. I was not their defendant, my lord. I was the plaintiff, decree holder. Now, here is the attempt to be made to execute a decree by the decree holder against the decree holder, my lord. That go against the, my lord, spirit of law. Now, lordship, really praise for column 10. It is therefore prayed that the decree passed in title suit number 96 2014 may be executed in compliance with all terms and conditions of the memorandum of settlement dated 27/3/2007. It is their assertion, my lord. Therefore, my lord, the compromise did this or that side, my lord, hold is field, my lord. Mere, my lord, incorporation of schedule in different tune, my lord, and trying to get an attempt, my lord, to execute the decree. It is totally in violation of that compromise deed judgment 27/3/2017, my lord. Now, lordship, one aspect of the matter is very important. The whole case is that, my lord, because the schedule, my lord, is in disturbing situation. That's why, my lord, the problem has created. Now, lordship, I like to draw the attention because, man, there is a solution that they may create a lot of disputed fact. I may also create a lot of disputed. Ultimately, decree required correction, my lord. Now, paragraph 87, the affidavit filed by the Chabua Town Committee, my lord. Kindly see for a moment.
No,
That's
if
point number
the
one.
decree is required to be corrected,
Yes,
you go and file an application
That's
before
right.
the court there.
Quite, lordship is quite right. I'm on that. My lord, affidavit filed by the respondent number 1,
Hmm.
page 87. They have already made an attempt because that application has not been, my lord, entertained because the pendency of this revision petition. The solution is here, my lord. Page 87. Just look for a moment, my lord. I'm on that, my lord. Respondent number 1, affidavit filed by the Chabot Town Committee, page 87. They made a declaration, paragraph 2. No one should be affected, my lord. We are on that, my lord. But question is that, my lord, the compromise decree which has been arrived at, that has to be implemented, my lord. Page 87, lordship, go to it. Affidavit
Yes.
in opposition, paragraph 2.
Hmm.
That in reference to the paragraph 1 and 2, it may be stated that, in fact, the title execution case number 2 of 2017 title suit carries wrong schedule for execution, as the said schedule mentioned there are the part of the claim. However, by virtue of the compromise deed dated 27/3/2017, the Honorable Trial Court by judgment and order dated 27/3/20 decreed the suit. Therefore, the state decree ought to have included the part of compromise terms in such a day in a schedule of the compromise, but unfortunately contained the schedule of the plaintiff, which is otherwise not possible to execute after having the compromise deed dated 27/3/2017 executed between the parties, as much as construction of new market after dismantling the old market. It is further required to mention that party to the correction of the decree in terms of the compromise entered into with the party, the necessary step has already been taken before the concerned court at Dibrugarh, and the matter is pending consideration before the court of law. This is the part of decree. Now, lordship, can you see the enclosure is in page 98, madam. This petition is pending for disposal. The executing court, my lord, need to take into consideration only the thing which, once this application will be disposed of by the trial court, my lord. Because decree required correction, there is no doubt to that effect, my lord. And that application number is, my lord, 8964/2025, filed on 18 September 2025. If lordship, this will be disposed of, my lord. Nothing survive, my lord. Whatever thing will come up, my lord. Application number 8964, my lord. Filed on 18th September 2025. Now, lordship, second aspect of the matter, my lord. The legal point, only one point I would like to raise, my lord. My lord, Order 22, Rule 6. My lord, read with section 33 clearly says, my lord, the decree must follow the content of the judgment. This is the one equation, my lord. Second equation, that at the time of filing application of for execution, the executing court also cast in duty to look into the aspect that the contention of the judgment must be the part of application filed for execution, my lord. A small, my lord, submission I have made there in my lord written form. Therefore, lordship, my submission only.
Yes, Mr. Chakraborty, what is you are for the Sabua Town Committee?
No, my lord.
Okay. What is the stand of the town committee? You were ready to provide.
Yes.
And Mr. Chakraborty, you are for?
In fact, when the agreement is lordship, as pointed out by learned additional lordship. Just, I would like to mention another point there, lordship, the compromise agreement. What was agreed between lordship at page 33,
Hmm.
last clause 4.
Hmm.
What was compromised between?
Hmm.
That the first party shall hand over the possession of the shop premises to the second party as per the record of the Chabot Town Committee before allotting the new shop premises to any other tenant. That was the assurance we have given to them. There are 27 plaintiffs. We will allot them 27 shops. Before, without allotting them, we will not allot any other person. That was the we have made commitment lordship. We have kept reserved 27 shops, but because of the new construction lordship, sizes got changed. We have to leave the road, etc., side area, set off, etc. So sizes, market size becomes small. So some of them, practically, they are responsible number 2 to 5, 6. They have got dissatisfied. Other 22 have taken their shops. Now during this execution proceeding, some order has been made that we are not willing. It is not at all correct, lordship. We have already allotted, we have in my affidavit, I have given that we have already written them, please take this off. Thereafter, again on consultation, we have offered them that if your sizes become small, we are ready to offer the first floor part also of the similars to make it bigger or to accommodate somewhere other part. But giving a particular area where the old shop was present now becomes infeasible. We have allotted after before allotment, all the vendors, all the plaintiffs have been after some negotiations, software allotted to everybody. Everybody, 27 we have allotted. The only dispute regarding site and the location. We are still ready. Give them shops and accommodation. If something later, we have repeatedly issued them notices. Please
Okay.
come,
Okay.
discuss.
Okay. Mr. Chakraborty.
This is a well recognized by my learned friend who are representing the petitioners. They are also degree holders. We are also degree holders. 5 members of degree holders. We are dissatisfied. My lord say, my learned friend has rightly pointed out page 33. My lord can kindly come for a moment, my lord, page 33. What is represented here, my lord? That's the last paragraph, paragraph 4. So the first party shall hand over the possession of the subpremises to the second party as per the record of the Sabua Town Committee before allotting the new subpremises to any other tenant. Now here lies the problem, my lord. Support town company, my lord, before allotting us, we already have negotiated with some third parties, my lord. With huge monetary consideration, my lord. Accordingly, my lord, they have given them, my lord, soft premises before us, my lord. And according to that extent, my lord, FIR was also filed against the earlier chairman, my lord. I will come to that, I will come to that, my lord. If my IA, I have filed another IA, my lord. I have annexed the FIR, my lord, there. It's not like that, what my knowledge, please has just stated, my lord. They are ready to willing, my lord. There are ample of spaces, my lord. As per the earlier allotment order, my lord, we could have been accommodated, my lord. That is another issue, my lord. What they have done, my lord, my learned friend's client, my lord, the so her space being is adjusted with another one, my lord. So they have, logically, they have reduced the space by themselves, my lord. They have made us to, my lord, adjust with some other, my lord, tenants, my lord, or other some third parties, my lord. That is why the problem started, my lord. Now, my lord, kindly see, my lord, they have filed a CRP, my lord, against an order dated, my lord, passed by the executing court, my lord. The order dated 27/5/25. What is wrong in this order, my lord? What is wrong in this order? If they have any grievances against the decree, whether they have filed any application under section 47, my lord, before the executing court, they haven't. They haven't filed any application, my lord. Now they are coming to this honorable court, my lord, to dispute those facts, my lord. When the decree was passed, it is a compromise decree, my lord. If at all they are not satisfied with the decree, the remedy would have been, my lord, order 23, rule 3, my lord. Challenging the decree. That they have not done, my lord. They have straightway come to before this honorable court and they have obtained a stay, my lord. And the last 1 year, they've been, my lord, enjoying the stay, my lord. And they are not agreed because, my lord, my line of friends, my lord, client has already been occupying the space, my lord. Compromising other space, my lord. So, my lord, then another thing, my lord. My learned friend has stated about an application, my lord. That affidavit in opposition filed with a support town committee. Kindly see, my lord. That affidavit dated. That affidavit was filed in September 25, my lord. Page 96. Page 96. September 25. And when this order was passed, my lord, 27/5/25. 27/5/25. This order was passed. So what he is trying to portray? And this is their petition, not his. If at all they have filed this, the support also has filed this application, that was after the input order was passed. Now, my lord, in 227, whether these questions he can raise, well, absolutely not. Absolutely not, my lord. He had not filed any application under 47, he did not challenge the decree under order 23/2/3, my lord. Kindly see, my lord. Order 23/2/3 for time.
Order 23.
Route 3, my lord. It's about compromise suit. May I read, my lord? Where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded and shall pass a decree in accordance therewith, so far as relates to the parties to the suit, whether or not the subject matter of the agreement, compromise, or satisfaction is the same as the subject matter of the suit, provided that where it is alleged by one party and denied by the other that an adjustment or satisfaction has been arrived at, the court shall decide the question, but no adjournment shall be granted for the purpose of deciding the question unless the court provisions to be recorded things fit to grant such adjournment. And explanation, my lord, an agreement or compromise which is void or voidable under the Indian Contract Act shall not be deemed to be lawful writing within the meaning of this rule. So, my lord, this is the law. If they are not satisfied with the decree, then the remedy would have been, my lord, an application on the order 23/2/3. To that extent, my lord, the honorable Supreme Court has also made it very clear, categorically has made it clear, my lord. May I write one judgment? This method, AIR 2006 SC 263. Pushpati Bhagat, Bhagat Rajendra Singh. In this judgment melody,
Hmm.
Mary Ferrat Registry. At the cost of repetition, we may recapitulate the facts of the case. This was expulsed for false by landlord against tenant filed in the year 93. Plaintiff's evidence was closed in 98. The contesting defendant did not lead any evidence, and her evidence was treated as closed. The matter was dragged on for 3 years for defendant's evidence after the conclusion of plaintiff's evidence. It was noted on 19/5/2001 that no further adjournment will be granted for the evidence. When the matter was finally came up on 23/5/2001, no evidence was tendered. On the other hand, the statement was made agreeing to vacate the premises by 22/1/2002. The trial court took care to ensure that the statements of both counsels were recorded on oath and signed. Therefore, it passed a consent decree. The attempts of the tenants in such matters to protect the litigation individually by raising frivolous and vexatious contentions regarding the compromise and going back on the solemn undertaking given to court should be deprecated. In this context, we may refer to the observation made by this court in similar situation in Srimati Jamila by Abdul Kader versus Sankarlal Gurupsa. On the facts of the present case, we have little doubt that the pleader has acted substantially, and this is the quotation of the earlier judgment method. And this is the next parameter. Similar facts are here. Neither the second defendant nor the legal representative has attributed any improper motive to second defendant's counsel. The facts go to show nothing further could have been done for the defendant's dinner. All the counsel for defendants had done was give the maximum notice to this client in the circumstance of taking on the matter to the extent possible. This ability therefore which has been counsel decrees are well, though for reasons different from those who wait with the High Court. The landlord will be entitled to seek main profits for the period from threshold to date of delivery position in accordance with law. The appeal is accordingly dismissed with force. And will be to for the moment. There are 22 found related to state by the appeal of this court is to contend that the compromise should be reduced in writing in the form of an instrument and signed by the parties to be valid under order 2323. He submitted that according to the statement of the parties, order counsel would not be an instrument of compromise. An instrument, according to him, the most regular document drawn up in the form of an agreement. We extract below the observations laid on by the appellant. Under 23, as it now stands, when a claim is has been adjusted only or in part by any lawful agreement or compromise, the compromise must be in writing and signed by the parties, and there must be a completed agreement between them. To constitute an adjustment, an agreement or compromise must itself be capable of being embodied in a degree. When the parties enter into a compromise during the hearing of a suit or appeal, there is no reason why the requirement that the compromise should be reduced in writing in the form of an instrument signed by the parties should be dispensed. The court must therefore insist on the parties to reduce the terms into writing. We have already referred to the definition of the term document. The term instrument used in Group C case refers to a writing of a formal nature and nothing more. Further, we'll have to understand the observations in the context in which they were made. In that case, when the hearing of a letter patent appeal commenced before the High Court, the parties took time to explore the possibility of a settlement. When the hearing was resumed, the appellant's father made an offer for settlement, which was endorsed by the counsel for the appellant also. The respondent who was present also made a statement accepting the offer. Evidently, the same offer and acceptance were not treated as final as the bill was not disposed of by putting those terms. On the other
Okay, oh, okay, Mr. Chakraborty, okay.
yes, well, so the law is very
So
clear.
according to you, this impugned order suffers from no irregularity
infirmity.
or illegality requiring
No
interference?
informative, nothing matter. And,
Okay.
I have got another point to make better.
Hmm.
They have annexed one Nazi's report.
Hmm.
But my lord, they haven't annexed the earlier Nazis report. That is the original Nazis report, my lord. My lord, kindly see. That is, my lord, kindly come to my lord, affidavit filed by one of the respondents, my lord,
Hmm.
respondent number. Sorry. Respondent number 6, my lord. There is an affidavit. my lord.
Page
Additional
number.
affidavit.
Page number.
My lord. Page 66, my lord.
Yes.
Yes, and the Nazis report at page 69, my lord. This Nazis report was not annexed by them, my lord. So, my lord, in this report, kindly see. I'm presenting Mohammed Hanif, my lord, and his legal heirs, page 74. Page 74. May I read, my lord?
Hmm.
Earlier shop number 389, 60 square feet, described in schedule 24, was in the name of Mohammed Hanif, decree holder number 23. He informed me that presently no shop has been allotted in his name by the judgment debtors against the aforesaid shop. Further, he intimated me that in the aforesaid place, the judgment debtors allotted shop number 16 to another person, namely Sunil Kumar Shah. And the decree holder also informed me that the actual size of the shop is more than 100 square feet. He has submitted some documents as proof regarding the earlier allotment of the lower floor of the said shop, as well as part of the first floor. The said documents are enclosed with the report. The decree holder is vested by his son Mustaq Hussain. Next page, madam. During the meeting with the decree holders and the judgment debtors, when the approval list was examined, the anomalies regarding allotment of shops came to my notice. When the judgment debtors were asked about the anomalies, they remained silent. So this is the position that they haven't conveniently, they have not annexed this report. They have annexed another report, which is subsequent to this report. And that says the some shops were closed. This is to be noted, madam. So, madam, in a 227 proceeding, madam, these questions he cannot raise at all, madam. There is no scope. You could have filed an application under section 47 if some disputes are there, or if the decree could not have been executed as per its form. Or
Okay.
an prediction of
Hmm.
It's more correct, by counter submission. Also, my learned friend is
Okay,
saying that
okay.
the decree has to be.
No, no, no,
Oh,
please,
sorry,
please.
sorry.
Yes, Mr. Pukesta, you have a-
I for other response. 2.2, 2.4 and 6 Australia.
So, your standing is same with Mr. Chakraborty.
Yes, in addition to that, Lordship, he has referred to the last report.
Hmm.
There are other report also, which is also covered. I have not understood how my learned friends, which petitioners have agreed with this order. Now, if we go to the compromise decree, schedule of the compromise decree,
Hmm.
they were also the plaintiff, they are also the decree holder. Admittedly, their share earlier, what area was they were possessing and what short number they are possessing, they cannot go away from this. It is their admitted fact, and this is the record of the Chavua committee also. Now, this petitioner number 1, Lordship, kindly come to page 41. 15.
Hmm.
Schedule 15, Shanti Devi, the petitioner number 1.
You have for Kanti Devi.
No, petitioner.
Okay, okay.
Petition. I'm showing their area. What was their actual area?
Hmm.
And that was the record because they were possessing the same. They have shown shop number 17, standing on a plot of land measuring 5 feet into 18 feet. That is 90 square feet.
Hmm.
Now,
at page 40,
Page number?
page 40, Lordship, previous page.
Hmm.
Schedule 5. Vishwajit Ghosh, one of the petitioners.
Hmm.
His room number was 356. And area is 7 into 2, it is 84 square feet. And other petitioner, this is legal heir of Suresh Agarwal, I think, Suresh
Hmm.
Agarwal. Is page 42. He has 185 to 42, schedule number 19. So this is the admitted fact of their original entitlement, original position. Now, respondent number 2.2, Lordship,
Hmm.
page 40, schedule 1. Respondent number 2, they are the legal heirs of this Anil Kumar Roy. Shop number was 29
Hmm.
and area was 180 square feet.
Hmm.
Then respondent number 3 is also 2.2, Orun Rai. Shop number was 32 and area was 180 square feet.
Hmm.
Then respondent number 4, schedule number 7. His shop number was 15, area was 180 square feet.
Hmm.
And respondent number 6 is schedule 27. Page 43. The stock number was 221, area 190 square feet. So this is the original, and petitioners cannot say that these are not the original. They had a smaller area. Now, then this is the record. Both the parties, this is record number 1, and they were emphasizing that in the agreement, it was set as per the record of the Chapa committee. And this is the record of the Chapa committee. We have other document also to show that record of the Chapa committee says that we were originally holding 182 square feet to 190 square feet. They were occupying lesser. Now, from the report as referred by Mr. Chakraborty, there also our part was also referred also. So we kindly come to page 7.
Yes.
Serial number 1, Lordship, Anil Kumar Raj.
Hmm.
He was the predecessor of Respondent 2.1 to 2.5. Earlier, shop number 29, 180 square feet, described in the schedule number 1 is the name Sri Anil Kumar Roy, decree holder number 1. Presently, shop number 71, 147 square feet. So they have reduced, given another shop in another place, location was changed, and area was also reduced. Allotted in his name by the judgment debtors was smaller in size and was not in earlier location, for which he denied to take the same. When he was asked about the earlier location, he stated the presence of number 63 is 183 square feet is in his place, which shop was already allotted in the name of Sunil Roy. Regarding allotment of shop of the decree holder number 1 could not arrive to any decision. The decree holder was represented by his son Sri Ajit Roy. During the discussion with the decree holders and the judgment debtors, when the approved list was examined, the anomalies regarding the allotment of stocks came to my notice. When the judgment debtors were asked about the anomalies, they remained silent. The Lordship, important thing, my location or shop was given another number and given to Sudhir Roy. Sudhir Roy is not a petitioner. So far as, so they cannot be agreed in my claim. Present petitioners. Now, second, Orun Rai. Earlier shop number 32, 180 square feet, described in sheet number 2. What's the name of Sri Orun Rai? Decree holder number 2, presently shop number 42, 89 square feet, reduced and different. Allotted in his name by the judgment debtors, was smaller in size and was not in the earlier location, for which he denied to take the same. When he was asked about the earlier location, he stated the present shop number 67, 155 square feet is in his place. The judgment debtors, by erecting the partition by wooden plank made
two parts, that is shop number 67 co and 78 square feet, and 67 co 77 square feet, and already allotted to same two persons, namely Srimati Kanti Devi, decree holder number 15, Sri Vishwajit and Vishwajit Ghosh, decree holder number 5. They are the petitioners.
Okay,
So this is
okay,
the way, Lordship. Whether,
Mr. Pukeso,
Lordship.
this court is not required to go into the factual aspect.
I am trying to show that how they are agreed. They
We
have
are-
come, petitioners have come.
We are only testing the legality of the impugned order.
Now, Lordship,
Yes.
my lord, kindly see, my lord, we have to find out only perversity, nothing, my lord. 27/5/2020 suffering from perversity, we have a case, and if it is not suffering perversity, don't have any case, my lord. That is the sole issue, my lord. Now, Lordship, that 27/5/2025 impugned order contained two parts. One part says that decree has to be implemented.
Hmm.
Second part contains that the schedule of that decree has to be handed over to them. Suppose we are occupying. Definitely we have been evicted. That's why we approach. There is a statement that we have already been called to vacate the premises at the time of Malon, Nazi Vijay, etc. Therefore, it is not a case that we are not being affected. It is a disputed fact. Now, Lordship, only one issue, my lord, required consideration. This creates a very big problem, and legal only treatment required. Page 39 for a moment. Only just look only one aspect. Page 39. This is the part of decree where it says that the compromise deed has to be implemented. Last paragraph.
Hmm.
That is my case, my lord. Title should dispose of being compromised by the party. Petition number 2, hereby made the part of decree, that is the compromise deed, and petition mark as so and so. Therefore, my lord, this is the order to be implemented. Now, just take it next on page 40. They want this schedule of land. Now, anywhere let them show in compromise deed, my lord, this schedule contain. That is my case. They want this schedule, my lord, here or there, but they want that this schedule has to be handed over to them. And that was the observation of the learned court below, saying that the schedule which is contained, that has to be handed over. Whoever there has to be evicted. The action was given to the police and Rajiv was to be implemented. Now, Lordship, in this situation, my lord, only one aspect of the matter is important. Order 21, Rule 17, my lord.
Hmm.
The duty cast upon the executing court, my lord.
Hmm.
Now it has traveled beyond that, my lord. That is my case, my lord. There is apparent mistake, my lord. Now, what duty cast, my lord? Page, my lord, Rule 7, Order 21, Rule 17, my lord. Page 174, my lord.
Rule?
Rule 17, my lord. My lord, it is the indication about procedure on receiving an application for executing a decree. But somebody suppose file an application on execution. Now, is it that the court will put a blind eye and, my lord, whatever thing is there, that has to be
No,
executed?
no, it was
That's
filed by the
that's why
decree,
my-
all right.
Exactly, that line is there, my lord. I'm
Yes.
reading, my lord. On receiving an application for the execution of a decree as provided by Rule 11, Sub-Rule 2, the court shall ascertain whether such of the requirement of Rule 11 to 14 as may be applicable to the case have been complied with. And if they have not been complied with, the court shall allow the defect to be remedied then and there within a time fixed by it, my lord. Therefore, my lord, if suppose decree contain that compromise deed has to be implemented, and if compromise deed suppose not speaking anything about the schedule part, which suppose they are referring in that schedule column, my lord. Therefore, my lord, this defect has to be corrected. The trial executing court has to look into that aspect in the light of the Order 21, Rule 17, my lord.
Okay, we will grant you liberty to
Now,
file an
that's why I'm
application
saying,
there.
my lord, solution is very clear because,
Hmm.
my lord, nobody should be affected, neither they or we, my lord.
Hmm.
My lord, question is that it is the case, my lord, where decrees are containing
So,
two
as per the decree, they have to be allotted first.
Absolutely. There is no problem. Everything, my lord. We don't want to disturb their part of allotment, my lord. What
Hmm.
I'm saying, my lord,
Hmm.
after this discussion, my lord, I think we agree to one aspect of the matter. The decree contains dual situation, my lord. One is compromised deed, on the other hand, it contains the schedule part.
Hmm.
So therefore, it should not be mismatched. It must be in consonance.
No, that's all
Therefore,
right.
my
You
lord,
go and file an application there.
my lord, what I'm saying, my lord, what I'm saying,
Hmm.
we have to be pragmatic, my lord, because my thing is that application 8964/2025
Hmm.
filed by the Chabot Town Committee dated 18 September 2025,
Hmm.
paragraph 2 is pending. If suppose that will be taken into consideration, my lord, until that will not be suppose or they should not be affected, my lord, then problem will become out, my lord. If suppose other they will be dissatisfied or we will be dissatisfied after of this my lord correction.
No, no, we will not go into that aspect. We will only consider whether the impugned order is legal or illegal.
Impugn order contain dual aspect, my lord. One
We'll
side
pass the-
saying,
We'll pass the
my
order.
lord, absolutely, my lord, the impugned order contain two aspects. One thing is that line is very much clear, that decree has to be implemented. And another aspect, the measurement of the land has to be given to them, my lord. But my lord, compromise deed, which is required to be implemented was part of decree. Nobody speaks the scheduled land which they are now asking for, my lord.
Mm.
So therefore, there is a perversity. Apart from my lord, order 21 rule 70
No,
clearly says-
that perversity cannot be determined in this.
Exactly,
particular.
okay, my determination is not a question. Question
Hey,
is
you
that-
go and file application before the trial court,
Absolutely, my lord.
executing court.
Absolutely, my that my lord, that
Okay.
liberty may be
Yes, and
granted,
next item.
and we will consider, my lord.
But just one.
My lord, my
IA is also there, madam. In an IA, madam, I just read for
no, I not maintainable. Our question is about maintainability, my lord.
what they have done, madam. I have two allotments. In the allotment, that is question, the other question is education, madam. What they have done, madam, they have one staircase. And that staircase was never there. We have inspected, madam, some reports, madam, though they haven't given us any certificate to be, when we have applied, madam. But, madam, there is no staircase in front of my shop, madam, and still they are constructing one staircase, madam. That is why we filed an IA, madam, for status quo of the construction. That is no doubt, madam, it's now, madam, long time has already passed, madam. Madam, may I just pray before this honorable court, madam? In the IA, if my lord disposes of this IA, madam, kindly, madam, it may be incorporated as per the decree, madam. Whatever actions they take, madam, as per the decree, madam. That's all, madam.
At one point, they are submitting that we have not allocated the shop. In the IA, they are saying, we have allotted ground floor and first floor.
That's
Staircase is
That's what I am required, that's what is, I am required to be allotted, my lord. They have not given allotment,
One
my lord.
position, how they can claim the injunction against the process?
No, this is just an,
Definitely a CRP injunction.
what is it? The 151 application also we have filed, because the allotment they were trying to give me, my lord, they, in front of that, my lord, they have constructed one stair.
Okay, all right, all right.
Yes, sir.
My lord, my only
One is-
limited, my lord, my only limited prayer, my lord.
Degree master citizen within 6 months, my lord, that is by settled by the. That is-
My lord, my only humble prayer, my lord, because. my lord,
Mr.
there's a-
Chakraborty, this is not the executing court.
Absolutely.
You go and show this judgment to the executing
Ma'am.
court.
My lord, only, my lord, humble prayer, my lord, that lordship may give us a liberty to approach before the concerned trial, my executing court, file appropriate application, my lord. Till that protection may kindly be granted, my lord. Otherwise, my lord, suppose, otherwise initiation will be taken, my lord, will be affected, my lord.
No, that against.
But he is already
Intervening in
my lord,
the
he said, my
impugned
lord, There
judgment,
must be
my lord.
rationally, my lord.
Careful amount to
Instead of
intervention
rushing to
in the-
Okay, we'll see.
My lord.
We'll see. We'll resume after 5 minutes.
May I please your lordship, I'm extremely sorry regarding item number 32. I'm on behalf of petitioner, I am not appear, so kindly my presence must be recorded.
Item number 32.
32,
Okay.
and interim may be continue, may I please your lordship. 18, deeply obliged.
Pending items. Item number 19 to 31.
No problem.
Same day on 27.
27.
Same issue, Lordship.
Same issue.
Same issue, same day.
Okay.
27, 2 PM, my Lordship.
Heard Mr. M.K. Sharma, learned counsel for the petitioner. And Mr. Gogoi, learned CGC for the respondent number 1 to
23, Lordship.
1, 2, 3. Mr. Bhattacharya for respondent number 4. Respondent number 4.
Park Council is there to-
Karbi Anglong, one lady was there.
She was there, Lordship.
Yeah. What is the name?
Temporary, sir.
Correct.
Temporary.
For the respondent number 5.
Was
This petition under Article 227 of the Constitution of India. Now, in this petition under Article 227 of the Constitution of India, the petitioner has challenged the judgment dated 19/6/2026 and the order of eviction dated 19/8/2025 passed by the learned District Judge Kirby Anglong Defoe in title appeal number 67 of 2025 and the eviction order dated 19/8/2025 passed by the state officer NF Railway Lambding in eviction case number W stroke 212 stroke LM stroke 4 stroke W dash 4 against the petitioner. It is submitted at the bar that similar matters are listed on 27th of July 2026 at 2 p.m.
Lordship.
at 2 p.m. And as such, এটা লেখা গৈছে এখানে
Yesterday I have paid for 2 p.m. Lordship. After I have some difficulties, I will be. Lordship.
okay, no problem. At 2 p.m. Okay, recessor list this matter
Yes.
on 27th at 2 p.m. Until then, the eviction process should not be initiated against the petitioner.
The matters are similar. The only title should have
31 mile.
should have defined. Lordship.
Are they earlier read petitioner? This petitioner?
Yes, yes. All are. All are.
Oblige your.
I think for admission, I can read.
Maybe lordship. We have challenged input order is 38 mile. Page 38 my lord. May I read my lord? Today, this case is posted for NO on petition number so and so. Petitioner and OP are duly represented by their learned engaged counsel. This case is initiated by the petitioner plaintiff by filing petition number so and so dated so and so under section so and so, praying for allowing him to file WS against CC filed by the OP dependent number 1 to 6. I have already heard both sides on this petition. Peruse the case record and the case record of the title suit. The petitioner plaintiff has initiated this case against the OP's defendant, praying for specific performance of contract and other relief. The OP defendants appeared in the title suit and filed their WS counter claim on so and so. Copy was received by the learned counsel for the petitioner plaintiff on the same day. In the present petition, the petitioner has submitted that as the next date was fixed for hearing under section 89 CPC and no date was fixed for filing WS against CC, the plaintiff side has not got any chance to file WS against CC. The OP number 1 and 3 has filed a written objection against this petition, whereon they have mentioned that plaintiff side willingly and negligently abstained from filing the WS against the counterclaim, though they got enough time to file the same and prayed for rejecting the prayer. On perusal the case record, it appears that though no date was fixed for filing WS against CC and during that period, COVID-19 pandemic struck. Issue are framed on so and so. On hearing both sides, the issue on both plaintiff and CC were framed. Thereafter, the plaintiff side has adduced their witnesses. The witnesses were cross-examined on CC. The defendant too adduced some witnesses who were cross-examined by the plaintiff side. Argument was heard by my learned predecessor in office, and during preparation of the judgment, it came to the learned court's notice that the plaintiff has not filed WS against CC and has recorded the same in the order dated so and so.
Thereafter, the petitioner or plaintiff has filed the present petition and the WS against CC with a prayer to admit the same. From the case record, it appears that the plaintiff side had due notice of the fact that the defendant number 126 has filed their CC in this case and intentionally abstained from filing any WS against the CC. Considering all, it appears that the petitioner or the plaintiff has failed to show any reasonable ground to substantiate his cause of not filing the WS against the CC till the same is pointed out by the learned court by order that so and so.
So you have not been allowed to file a
WS
written statement against the counterclaim.
counterclaim. My lord. Now
Okay.
kindly see, my lord, page 29, my lord.
So why you could not file the written statement within time?
Kindly see, that is why, my lord, page 30, my lord. Page 30, 30, my lord. My lord, got it?
Yes.
Yes. Order dated 23/12/19, my lord.
Hmm.
Learned advocate for plaintiff file Hazira. Defendant number 126 submitted written statement furnishing copy of thereof to the learned counsel for the plaintiff. Here, my lord, it is mentioned written statement, my lord. But this is not only written statement, this is written statement come counterclaim, my lord. So in this order, my lord, there is no reflect of counterclaim, my lord. And the matter, my lord, kindly see, lastly, fixed so and so for settlement under section 89 CPC. Then, my lord, on the next date, my lord, 26/2/2020, learned advocate for both sides filed Hazira. Nothing communicated in respect of settlement of the matter in controversy between the parties through ADR mechanism. Situated thus, this suit deserves to be posted in regular course, fixed so and so for issue and document. In this case, my lord, there is some mistake on the part of the petitioner's counsel also there, my lord, but court also never fixed the matter for filing WS against the counterclaim, my lord. I have the entire order sheet, my
No,
lord.
no. Is it necessary to fix it that for filing a written
That
statement?
is, my lord, there in the, my lord. Kindly see. Order 8, rule 6A3, my lord.
Order 8 rule.
Order 8, rule 6A3, my lord. The plaintiff shall be at liberty to file a written statement in answer to the counterclaim of the defendant within such period as may be fixed by the court.
No, you could have mentioned the matter there.
Yes, my lord. That is there, my lord. Some, my lord, mistake on the part of the engaged counsel also there, my lord.
That you are going to file a written statement,
Yes,
then
yes.
you may be granted some time.
But that is, my lord, ignored by the learned counsel, engaged counsel, as well as my lord court also. my lord. And ultimately, my lord,
Unless it is submitted before the court below, how the court will know that you are going to file a written statement or not?
normally, my lord, when WS counterclaim is filed, my lord, normally court fix the matter for my filing WS, my lord. And in the first order itself, my lord, there is no mention of counterclaim, my lord. Ultimately, the matter was overlooked and through the entire proceeding, my lord.
When did you file the counterclaim there?
No, I
No,
filed an
so when the defendant filed counterclaim?
on 23/12/19, my lord.
On 23/12/2019, along with the written statement.
It is the, my lord, written statement come counterclaim, my lord. No separate counterclaim. Kindly see that is there, my lord. Page 22, my lord.
No, you show me the order on who is that the counterclaim was filed?
Yes, page 30, my lord.
30.
Yes.
Order dated?
23/12/19, my lord.
Okay.
Defendant number 126 submitted written statement furnishing copy thereof to the learned counsel for the plaintiff. This is, my lord, written statement come counter claim, my lord. So counter claim was not mentioned in the order, my lord.
And where is the written statement?
Yes, my lord. Page 22, my lord. Page 22. Written statement come counter claim.
And thereafter you have filed application, or where is that application?
Yes, my lord. Just
31?
Page 31, my lord. Actually, this fact was pointed by the learned trial court itself, my lord, while preparing the judgment, my lord. That not filing of written statement and the counter claim was, my lord, indicated by the learned court, my lord. Then, my lord, this petition was filed, my lord. Page 31.
Yes, Mr. Halloy.
My lord, here the petitioner has remained silent throughout the trial. And when the learned court fixed the case for judgment, they filed this petition, my lord, under section 151 for filing the written statement. Now, my lord, they are saying that they have no knowledge about the counterclaim by showing an order 23rd, 2019.
No, the judgment was pronounced.
No, no, it is fixed for judgment, my lord.
Okay.
Thereafter, they have filed this petition, my lord.
One second, my lord. Matter of fixed for judgment, on the date of judgment, my lord, learned court, my lord, indicated that that thing that no WS was filed against the counter claim, my lord. The ultimate judgment was not pronounced.
In which order it is reflected?
Well, they have not had a certified copy, my lord.
Okay.
On 25/7/2025, the plaintiff and defendant are represented and learned in his counsel, heard learned counsel on law point, fixed 26/8/2025 for judgment. Now, my lord, they have filed this petition on 2/9/2025. This petition, while the learned court, my lord, on 26/8/2025. I have the order, my lord. On 26/8/2025, my lord. Matter was heard, it is fixed for judgment, my lord. On 26/8/2025, an order was passed by the learned court bill. And serial number 3, on revision of the record reveals that the defendant submitted his statement along with the counterclaim, but the plaintiff did not submit the statement against the counterclaim. The record further reveals that after filing the written statement from counterclaim by the defendant, the suit was fixed for settlement under section 89 of CPC instead of filing the written statement against the counterclaim. Hence, I think deem it fit to hear the parties on the issues, and next it was fixed on 29/8/2025. Then on 29/8/2025 also, my lord, they have not filed any petition. This petition was filed thereafter, my on 2/9/2025. Now, my submission before this honorable court, they are by showing an order to 23rd/12/2019, they are saying that they are submitting that, my lord, they have no knowledge about the counterclaim. Now, my lord, they have technically filed this petition and they have not annexed the order of issues fixed. But I am submitting the order and the issues. And while they are, the issues were framed on 20/12/2020. Now, before the draft, the issues were framed by the learned court below, my lord. They have submitted the draft issue, my lord. I have submitted the copy of the next bill file. In their draft issue, they have submitted the issue number 7 and 8 on my counterclaim. It is there, my lord. So they have the knowledge about my counterclaim in the year 2019, and they have filed this petition, my lord, in the year 2025. And when the case is fixed for judgment, my lord. And by filing a petition under section 151, they are seeking, my lord, reopening the trial. They have cross-examined the defendant, my lord, as counterclaim. In my evidence on affidavit, my lord, submitted before the learned court below, I have submitted, my lord, my evidence as counterclaim, as counterclaimant number 1, 2, and 3, 4, 5, 6, my lord. So they have cross-examination me, my lord. So they have the full knowledge about the counterclaim. They have also submitted the draft issue before the learned court below in the year 2020.
Mm.
And accordingly, the learned court below has also issues are
So,
framed,
till passing of the impugn order, they remain silent
remain silent, my lord.
throughout the trial.
My lord.
Okay.
Across the trial.
So according to you, the impugn order suffers from no infirmity.
My lord.
That is your submission.
My lord. And because they have full knowledge about this, the counterclaim, my lord.
So is it not a waiver and acquiescence?
My lord. Admittedly, my lord, advocate, learned engaged advocate, my lord. He
That
has
is not-
committed some mistakes, my lord.
That is not the
But
ground.
being a litigant, my lord, petitioner, my lord, being a litigant, he cannot, my lord, understand, my lord, everything before the what happening before the court, my lord.
That cannot be the ground.
And my lord, court also did not fix the matter, my lord, for
Mhm.
filing written statement against the counterclaim any point of time. I have produced the entire order sheets, my lord.
No, you have the knowledge, you have received the copy of the written statement counterclaim. Then it was your duty to point it out to the court that I may be granted some time to file a written statement against the counterclaim. You have done nothing till
Yes.
2025.
Yeah, that is there, my lord. But admittedly, my lord, for the
Then-
fault of the, my lord, engaged counsel, my lord.
No,
So
that
petitioner may
principle
not suffer, my lord.
you cannot apply in all the cases.
And learned trial court also, my lord, order dated, my lord. The lordship already gone through, my lord, 26/8/25, my lord. Indicated that, my lord.
Maybe. After a long period, where is the question of reopening the matter again? Hmm? You have waived your right. One aspect is there, that is at the relevant point of time, COVID-19 pandemic was prevalent.
Yes, my lord.
But thereafter, what happened?
My lord, thereafter, my lord, the issues will frame, my lord. And during the date fixed for
Issues were framed when?
on 2012-2020, my lord. I have submitted the copy. 2012-2020.
2012, 2000?
2020, my lord.
Mm.
My lord, when the learned court below fixed the date for issues and document, my lord, they have submitted the draft issue, my lord. And where they have mentioned, my lord, in issue number 7 and 8, they have submitted draft issue regarding my counterclaim, my lord. So they have knowledge since 2019, my lord.
Okay, we'll pass the order.
Obliged, my lord. Highly obliged.
For hearing. Adjourn. 11.
No, 11, adjournment. Oh. Yes,
Your Honor, matter may be heard in any other day. My senior counsel is not appearing today for his personal difficulties.
heard, Mr.
Y. Sharkar.
Learned counsel for the appellant. None appears for the respondent on call. Place the matter after a week. The learned counsel for the appellant also submits that conducting counsel Mr.
Y. Sharkar.
Y.A. Sarkar is no, has some inconvenience, also has some inconvenience today. Accordingly, the matter stands adjourned to be listed after. But the name of Y.A. Sarkar is not there in the cause list.
Yes, okay. I am behalf of S. Sharma.
S. Sarkar is not there.
Y. Sharkar. I am behalf of S. Sharma.
S. Sarkar's name is not there.
Y. S. Sharma, not S. Sharma. S. Sharma.
S.
Satyen Sharma.
Sharma.
Yes.
S. Sharma. Okay.
Item 12.
2010 matter. Later the deadline to quit left. Can quit it.
Item 12.
I am appearing for respondent number 1 and 2, my lord. Last decision, so my lord.
Okay.
Also not appearing, my lord. Last 2-3 occasions.
None appears for the appellant on call. However, Mr.
K within, my lord.
K. Uddin, learned counsel for the respondent present. It appears that this appeal was listed on 10/2/2026, on which the appellant remained absent without stay. Thereafter, it was again listed on 2/3/2026. And on that day also, the appellant remained absent. Thereafter, it was again listed on 29/4/2026. And on that day also, the appellant remained absent. Today also, the appellant remained absent. Learned counsel for the respondent, referring to the order dated 29/4/2026, submits that an observation was made in the said order that in the event of subsequent non-representation of the appellant, appropriate orders shall follow. Accordingly, the counsel for the respondent contended to pass appropriate order. Whereas since on 4 subsequent dates, the appellant remained absent continuously without any step, this court is left with no other option but to dismiss this appeal for non-prosecution. Accordingly, this RSA is thus dismissed for non-prosecution. Rest shall return the record of the learned trial court as well as first appellate court for to it.
Item 13.
Worship.
This case, my lord heard the matter also.
Hmm?
Some length. My lord has heard the matter some length.
Hmm.
But so we say this statement. Now, this is an, my lord, appeal. My lord, the preferred against the, my lord, order of the first appellate court. Lordship will find that page, my lord. 2/4/2013, my lord. In title appeal number 35 of 2028. Now, my lord, the facts of the case is that, my lord, in a nutshell, my lord, the suit plan, my lord, actually is comprised in a patta, my lord, patta number 62, dag number 339, 340, 340, and 342 and 35, my lord. My lord, is price of 9 biga, 14 kata, 8 chatak of land, my lord. Now, original owner was on Indeshwar Mahanta and Joladhar Mahanta, my lord. My lord, their name will reflect from the, my lord, the Jamabandir Exhibit 2, my lord. Now, my lord, this land was purchased by one Girish Namashudra, my lord. In auction purchase, my lord. In an auction purchase. And my lord, and the Girish, at the time of the purchase, my lord, it was in, my lord, in the year 1960, 76, 77, my lord. And in that, in the, my lord, the
you
time
see,
of purchase,
uh,
let Joladhar Rai,
Mr. Ghosh,
lordship.
Jalandhar Roy, you come to first substantial question of law.
Yes, my lord.
Jalandhar Roy,
Yes.
he is not the
My lord,
not,
my lord, the substantial question of law on which that admitted that whether the learned court below are they not considering the evidence of PWD number 3, my lord. Lordship mechanism.
no, one.
Substantial question number 1.
Yes, my lord. Yes, এখানে তো নাই। Yes, my lord. এখানে লাগাই নেই। Yes, ma'am. For that, the substantial guarantee as to whether the plaintiff number 1, it had the status of the tenancy right of the predecessor Jalandhar Roy is evident from the evidence of landlord defendant number 3. And in that view of the matter, both the court committed illegality in holding that the Nirod Rai is not the adopted son of the Jalandhar Rai, my lord. So here, my lord, the evidence of DWD3, my lord, it will be rather PWD3, my lord. They have mistake, my lord. PWD3 was not considered by the, my lord, trial court after remand, my lord, because that case was originally decreed in the favor of me, my lord. Then the defendant, my lord, went for an appeal, my lord. In appeal, the decree was set aside, my lord, and the matter was remanded to the trial court for a fresh trial, my lord, the framing two additional issues, my lord. Framing two additional issues, lordship. Now, my lord, I will just submit, my lord, for that purpose. That will be, in my humble submission, convenient to my lord. My lord may look into this, my lord. This is, my lord, the judgment, my lord, by which, my lord, the suit was decreed in my favor, and, my lord, the appellate court judgment by which the decree was set aside, remanded the matter to the trial back for a fresh trial, framing two additional issues. Lordship may look into issue number 6 of that.
No. Come to the substantial question of law.
Yes, I am coming to that, my lord. Because my question is this, my lord.
Now the question is in view of the substantial question of
Yes.
law number 1, who is Jalandhar Roy? Who is Jalandhar Roy?
My lord, Jalandhar Rai was the, my lord,
uncle of my lord, the plaintiff number one, my lord.
Hmm.
Was the uncle of the plaintiff number one, and according to our pleading, my lord, he was an adopted by his uncle Jalodhar Roy, my lord.
Hmm.
And the evidence of the PW3, my lord, which has dealt with that issue, my lord, he has deposed, but that evidence was not considered by the, my lord, trial court after remand, my lord, which was considered by in the earlier, my lord, round of litigation, by which, my
No,
lord,
whether any document was produced that you were the adopted son of Jalandhar Roy,
my lord, no such document in my humble submission is required, my lord.
then
As I submitted a judgment, my lord,
Hmm.
because it is a matter of ritual of my lord, the lordship will kindly see the provision of the
whether
Hindu
no.
my adoption and minority act, my lord,
Hmm.
adoption and maintenance act, my lord. What it said now. Section 6, my lord, section 6. You start from section 6, lordship. Now, my lord, section 6 says, my lord, requisite of a valid adoption. Lordship, my lord has got section 6 of the Hindu Adoption and Maintenance Act. No, may I read, lordship?
Hmm.
No adoption shall be valid unless the person adopting has the capacity and also the right to take in adoption. The person giving in adoption has the capacity to do so. The person adopted is capable of being taken in adoption, and the adoption is made in compliance with the other condition mentioned in the chapter,
Hmm.
my lord. Now, lordship will find
So the trial court has decreed the suit.
trial. Originally, it was decreed in my favor, my lord.
Hmm.
Against the defendant gone for an appeal, first appeal.
Therefore,
first
the
appeal-
appellate court has set aside the judgment and decree
yes,
and
yes,
remanded the matter to
Yes.
the trial court.
Framing two additional issues.
Then trial court.
Then trial court, my lord, dismissed my suit. Earlier, it was allowed my suit.
Mm.
And then, my lord, they dismissed my suit. I
Mm.
went for the appeal. The appeal court also dismissed my appeal. So there is a second appeal, my lord. Why I am, my lord, just submitted the judgment of this, my lord, first judgment, my lord, in which decree was granted in my favor.
No, that has been set aside. Why should we consider it?
My question is this, my lord. My evidence of PWD3, which was taken into consideration, that was not considered by the trial court while it was remanded.
Mm.
After remand, it should have been taken the evidence in toto, my lord.
Mm.
In earlier judgment, it court has taken that, my lord, the evidence of PWD3.
Mm.
In the remand, when it was remand, there is no whispering of the in the judgment that the evidence of PWD3 has been taken into consideration, my lord. And this is, my lord, important because it connects with that, my lord, substantial issue number 1. Issue number 1 is regarding adoption. Issue number 2 is, my lord, whether the trial court has. It is important, my lord. Now, why I am not relying that we should rely on that, my lord. But for the purpose of, my lord, elucidating the facts of the case, I have produced the judgment of the earlier judgment, my lord. Issue number 6. May lordship may kindly say.
No, the fact is that that judgment has been.
They are the evidence of the PWD3 has been considered, my lord.
That is no longer in existence since it has been
Yes,
set aside.
but the evidence is not apparent yet. Evidence of PWD3
Evidence
remains on the
will go
record.
to the record.
Yes, my
We
lord.
will go
Yes.
and see the original record.
Yes, my lord. Lordship CPWD3.
C1.
Which number?
এইটা না? হুম।
Do you have the translated copy?
Yes, my lord. I have. Worship, I can, it is recorded আছে to translate. করেছিলাম না? কোটো প্রায় করে দিয়েছিল। কোটো ডাইরেকশন। আমার কপি রশিদ মেঘ টিকিট দাও। কপি আছে। একটু দিতে। একটু দিতে। Rashid, I am just providing a copy. We have a. Rashid. You have it.
And who is it, this Rosik Roy?
My lord, the
PwC?
Yes, my lord. Roshik Rai is the my lord the predecessor, my lord the successor in interest of my lord Jolodhar Rai, under which I was a landlord, my lord. Sorry, my lord, of my lord the Girish Namasutra, of Girish Namasutra, my lord, of Girish Namasutra, under which my uncle holding a occupancy right, my lord. He is the son, my lord, except my lord the respondent number, my lord, 8, 11, 12, 13 of the appeal memo. They are all the, my lord, the successor in interest of the, my lord, the Girish Namasutra. And Girish Namasutra purchased the land, my lord, as I stated, from my lord, the Indeshwar Mahanta in 1976 through an auction sale. And thereupon he devolved on him. And I was a occupancy tenant under my lord, my uncle was an occupancy tenant under Girish Namashudra. After demise of the Girish Namashudra, I live with my, he adopted me, I live with my aunt. After my aunt was also, my lord, expired. Then my lord, I'm in a position of having the tenancy right. Well, and this has been admitted by PWD3 in Siroshik Rai, with the son of the Joladhar Rai. Sorry, so Girish Namashudra. Sorry. रामकुमार है प्लेंटिफ नंबर 2 निरोध राय केस को नहीं वो रामकुमार है निरोध है then निरोध है टाइटल है এটা প্রশ্ন
So going by the evidence of PW3, can it be said that Nirud Roy is the adopted son of Jalandhar Roy? Where is the averment? Where is the evidence?
My lord, evidence, lordship, among the petition আছে the position of my lord, PWD 1 Nirod Roy, phase 1.
Hmm?
Before PWD 1 Nirod Roy.
No, why should we go to the PWD1? Reference is there of PW3 in the substantial question of law.
And PWD 1 is the Nirod Roy, my lord. PWD 1 is the Nirod Roy, my lord. Is also reported with the court, my lord.
It is a DW3 or PW3? Yes, Mr. Chaudhary. Huh?
PWD 3.
PW3.
It is there in the judgment also.
PW 3.
Okay.
Only mentioned that the plaintiff is the nephew, but there is no plaintiff is the nephew. The is there, it is also reflected in the judgment also. But there is no mention whatsoever with regard to the fact that he was adopted by the original, this.
Jalandhar Rai.
Jalandhar. So first of all, he should show that he has the legal rights to
Yes,
institute this. So there is no documentary evidence, no nothing like that, and that's why the learned trial for the appellate court frame the issue with regard to the social and legal recognition of the plaintiff to claim right over the suit. So if he has failed to establish his right over the with regard
Suit
to
property.
being the legal heir or something like that, then the other things will go ahead. So there is no documentary evidence, nothing like that, and these are all disputed questions of fact law. So there is no substitute question of law. No perversity of finding.
no. Perversity, there is no substantial question of law on the point of perversity.
Exactly.
Mhm. Yes, what is there in the evidence of PW1?
My lord, your it is a translated copy of the PWD one is also there.
Hmm.
Page number 1. Start from page number
Follow.
1.
Yes,
My lord, I am the plaintiff number 1 to this suit. Plaintiff number 2 is my nephew, sister's son. The suit land measure so and so covered by double under so and so under arrest patta number 62 located at so and so Porgona under so and so Moja. The suit land includes both my house and my agricultural land. The original owner of the land was Prodon Mohanto Indeshwar Mohanto. The said land was put on auction in 1976-77. Late Girish Chandra Namashudra, the father of the defendant number 227, bought the said land in auction. And at the time of my paternal uncle, Kaka Joladhar Rai, was in possession of the suit land as a tenant riot. Girish Namashudra accepted my parental uncle as occupancy tenant. My paternal uncle did not have any child, hence he brought me to his house and raised me. My said paternal uncle died in 1978. My paternal uncle died in 1977, leaving my paternal aunt, Kakima and Kakima Chintamuni Roy and me. My parental aunt also died in 1984, leaving me behind. I had been enjoying the possession of the suit land, and since after the death of my parental aunt in 1994, I executed Swarnolipi to sell Jyoth right and interest in respect of the suit land to the plaintiff number 2 and transfer the suit land to him. I execute the said Swarnolipi on 4/3/1994. Exhibit 1 is the Swarnolipi written exhibit 1/1 and 1/2 are my signature. I do not remember who are the witnesses. Swarnolipi. Plaintiff 2 has staying with me since 4/3/1994. Plaintiff 2 allowed me to stay with him after I had sold my Jyoth right and interest over the land to him. After I had executed Swarnolipi, a suit was instituted in 1995 to evict defendant number 2 and me from the suit land. Since defendant number 2 did not submit a written statement in the suit was declared ex parte in favor of the defendant number 1. Plaintiff number 2 and I were not aware of that suit. We were not made parties to the suit. I could know about the suit from my fellow villagers in the month of September 1996. Exhibit is to the certified copy of the judgment and the decree of the TS number so and so. And the area of the land in that suit and that of the suit, area of the land in that suit and that of this suit is the same. In this suit, I did not have any claim against the government of Assam. I submitted a petition to amend the pair number 4 made in the suit, but the said petition rejected. The boundaries of the suit land are as follows. My house is located within the above mentioned boundaries. Exhibit 3 is the certified copies of the Jamabandi of the suit land. I have submitted the photocopy of the order passed in say so case number so and so to the court. I pray for the relief mentioned in it. Then, my lord, I cannot say what is the total area of land under patta number 62. I cannot say how many pattadars, pattadars, pattadar in that patta. After the death of my parental uncle, I myself perform this saddha. I know Jointo Rai, it is not a fact that my fellow villager did not allow me to enter the house and that it was Jointo perform the Shraddha. It was not a fact that Jointo Rai is the adopted son of the parental uncle. I do not know if there is any agreement between defendant number 1 and defendant number 2. I do not know if there is an agreement between the defendant number and defendant 2 on 14/11/1994 regarding the sale of the suit land. After considerable period of disposal of the TS suit number 125 of 1994, I institute this present suit, which is currently pending in the court. I have not submitted to the court showing that I have just right interest on the suit line. It is not a fact that I have been enjoying the possession of the land since after that of my aunt in 1984. It is not a fact that I have no possession of the suit land and that I have instituted the suit making false averment so and so. This is the my lord thing. Now my lord will plaintiff number 2, same evidence, my lord, Ram Kumar Rai, to whom I my lord transfer the jute right of the land, my lord. Now 1, 2, and my lord plaintiff number 3 taken together. Now plaintiff number 3 evidence also my lord throwing light that my lord, yes, he has been adopted by my lord by the my lord Joladhar Rai, my lord.
No, you come to this evidence of PW1,
Yes, my lord.
where he has stated that he is the adopted son.
Lordship, may I submit one thing, Lordship? This issue with regard to the fact, tip number 1, is not the adopted son of the Joladhar is attained finality because of the fact this Nirod Roy is not a party in this particular facility, Lordship. Nirod Roy has not assailed this particular offer. He is part to the second degree. Only the subsequent person, Ram Kumar Rai, who has projected himself that he has purchased the property from Nirod Roy, who claimed to be the adopted son. He is not a party. So if the Nirod Roy is not a party to the second degree, so he cannot raise all these issues with regard to the adopted son and all these facts. Because that is at a finality. He is not challenging that aspect of the matter. Only the Ram Kumar Roy has this order. Now he has to take a call with regard to the subsequent sale by Nirod. Because Nirod Roy has not filed the appeal. That is at a finality.
So there is a finding that Nirud Roy is not the adopted son of Jalandhar Roy. That is the that proposition is affirmed by the first appellate court also.
Exactly.
And Nirud Roy has not challenged the said finding. Okay. Okay, we will continue at 2 p.m.
I'll spend that point maybe, because it is a common defendant, my one appeal is another.
Pardon?
My lord, because the defendant number 1 and 2, my lord, they are having the common interest, my lord, because defendant number 2's interest derived from the defendant number 1, my lord.
It's not the attorney.
My lord.
Okay.
Item number 15, Lordship, we need some accommodation, Lordship. Kindly, let's have the 4 weeks.
Okay, you come at 2 p.m.
In respect of item number 11, earlier, Mr. G.C. Fukon, P.C. Borpujari and myself used to appear in that matter. Subsequently, we got disengaged. But the names keep on appearing and sometimes there is inquiry that where are the lawyers appearing.
Item number?
11.
We have already passed the order.
Yes, I could come to know only before after the matter was taken up. So
Now,
that
what is to be done?
our names may be deleted, Your Lordship.
Later on. Mr. Your name, please?
A.K. Chaudhary.
A.K. Chaudhary, Learned Counsel. Engaged earlier for the respondent. Submits that they have been disengaged by the party and the brief was taken away.
Taken away. It was
No, taken back by the respondent. And as such, he submits that their name may be
struck off,
deleted
deleted
from the cause list.
G.C. Fukon, the names are G.C. Fukon, P.C. Borpujari, B.K. Singh and A.K. Chaudhary. I think H. Thakuria probably appears now. Her name is shown.
Name of Mr. G.C. Fukon, P.C. Borpujari,
A.K. Chaudhary and B.K. Singh.
A.K. Chaudhary and B.K. Singh may be struck, may be deleted from the cause list. Rest shall do the needful.
Obliged.
Yes.
May I please, Your Lordship? Your Lordship, in item number 15, we need some accommodation, Lordship. Kindly the matter may be
Item
listed
number
after
15.
4 weeks, Lordship.
Lordship, I will respondent number 1 and 2. On behalf of Mr. Mandela.
Okay, as agreed by learned advocates of both the parties, recessal is the matter. After?
4 weeks, Lordship, any date.
After 4 weeks.
Lordship, kindly let it be fixed.
Take a date from him.
Bless.
September.
Yes.
Section 30 continue.
So, Mr. Ghosh,
Lordship,
this PW1
my lord,
who claimed to be the adopted son
yes,
of Jalandhar Roy,
my lord.
he has never whispered any word that he was adopted by Jalandhar Roy in his evidence,
Yes, my lord. But,
right?
yes. Then my,
And
Yes.
your contention is that you have inherited the suit property from Jalandhar Roy.
lordship.
That is your contention.
Yes, purchased.
No.
The appellant hearing, he has purchased the property. It's the unregistered document. He is not appearing for the.
Transfer of the jot right, my lord. No, it's not a, my lord.
Acha,
Ah,
acha.
Yeah, transfer of the jot right.
The original plaintiff number 1 is not there in the, before this order. And that order with regard to the fact that. he is not
Plaintiff
the
number
adopted
1
son.
that attained finality.
Finality. So subsequent purchase.
And you have purchased it from
From the plaintiff number 1.
Jot right, my lord.
plaintiff
Jot right
number
was
1.
transferred By the plaintiff, from plaintiff number 1 to
No,
plaintiff.
then
number two.
first you have to establish that plaintiff number 1 has the right title interest over the suit property.
My lord, right title interest, sir, my lord, it is by virtue of, my lord, the right conferred under Assam, my lord, the temporary area settled tenancy act of 1971, my lord.
Mm,
I have submitted on that point, my lord.
mm,
Assam temporarily settled areas tenancy act 1971.
mm.
Lordship. Now, my lord will find here, my lord, chapter 2.
Mm.
And so far this way, whether, my lord, the I filed the appeal, I do not file the appeal, whether it is a part, I'll place that judgment as well as the provision of the CPC also. My lord. My lord, now will chapter 2, my lord, will Assam temporarily settled areas tenancy act 1971.
Mm.
My lord has got it, my lord.
Mm.
Section 4.
Mm.
Class of the tenants, there shall be for the purpose of this act only the following class of tenants, namely occupancy tenants. That is to say, tenant holding immediately under a proprietor, landholder, or settlement holder other than the landholder, and having a right of occupancy in the land held by him, my lord. Now, non-occupancy tenants, this is not required, my lord, for our case, in my humble understanding, my lord. Now, chapter 3, my lord, acquisition of occupancy right. Section 5. A person who for the period of not less than 3 years.
You were reading section
5, my lord. Section 5, my lord. I've read, my lord, section 4, clause 1, and then I'm going to, my lord, section 5 of the act. Section 5 of the act.
Mm.
Acquisition of the occupancy right. A
Mm.
person who for a period of not less than 3 years continuously held land as a tenant shall have a right of occupancy in that land. A person shall be deemed for the purpose of this section have continuously held under a landlord, notwithstanding that a particular lender under whom he held the land was different at different times, provided the land held by him was the same. A person shall be deemed for the purpose of this section to have held the land as a tenant in any land as a tenant by a person who here he is. Now, my lord will find section 7. My lord has got it. Section 7. Devolution on death. If a tenant dies intestate in respect of a right of occupancy shall subject to any custom descent in the manner other than other immovable property devolves, my lord. Now here, my lord, in this case, lordship will find that, my lord, it is a admitted fact. Nobody has denied that, my lord, my aunt, Jolodhar Rai, was a tenant under Namashudra.
Hmm.
And I have been, my lord, no, not in many words, my lord, but if your lordship again read into, my lord, the evidence of PW1, my lord, again the evidence of the, along with the evidence of PWD3, my lord. I'll kindly, my lord.
Hmm.
It is not also the fact that I was not occupying the land. My aunt is not, my uncle was not occupying the land. That is not a case, my lord. There is nothing in the evidence, nothing in the judgment that we are not in the possession of the land, or my uncle was not in the possession of the land. So therefore, it is not a case trespasser also, my lord, that I have just entered into the land and occupying the land. It's not that. Now, therefore, my issue is this: how I have come to the possession of the land, my uncle and then me.
Hmm.
So, well, from that perspective, in my humble submission, my lord, matter may be looked into, my lord, along coupled with the evidence of PWD1 and PWD3. Now, PWD1 says, my lord, if your lordship kindly see, again, my lord, I am the plaintiff number 1 to this suit. Plaintiff number 2 is my nephew, sister son. The plaintiff land measuring 9 bigger so and so, so and so, so.
No, no, you directly come to the relevant point
No,
where
no,
he
yes,
has
my lord.
deposed.
Yes, my lord. Yes, the said land was put in action, my lord. I am not said. Action in Girish Namashudra, the father of defendant number 2 to 7, bought the said land in auction. And at that time, my parental uncle Kaka, Jolondhar Rai, was in the possession of the suit land as tenant Rai.
Hmm.
So that fact is not denied by anybody, my lord. In my humble submission, this
No,
fact
that's
is,
all right. How the property devolve upon you, descend
my lord,
upon you.
I am coming to that, my lord.
Hmm.
My paternal uncle did not have any child.
Hmm.
My paternal uncle did not have any child, hence he brought me to his house and raised me, my lord.
Hmm.
In my humble submission, sense of this technicalities, my lord, there is a pointer towards the fact that yes, I've been adopted.
Hmm.
So, my lord, after demise of my uncle also, I continued the possession. It's not that, my lord, I enter into the possession of the land after demise of my uncle. But on the contrary, it is a fact that I have been occupying the land. I have been staying with my uncle. After the death of my uncle and aunt, I was possessing the land. And therefore, my lord, in my humble submission, the land devolved on me as my lord, be governed by Section 7 of the 1971 Act. Now, my lord will find my
No, no.
paternal uncle so and so.
You see, devolution of debt,
Yes. Yes.
Section 7,
Section 7.
subject to any custom,
Yes.
descend in the same manner as other immovable property, as other immovable property.
That is, my lord, custom. That is, if it is governed by any other custom. Here, my lord, we belongs to Hindu.
Subject to custom.
We belongs to Hindu, my lord.
Hmm.
So therefore, my lord, the Succession Act, Indian Succession Act, will apply in this case also, my lord.
Hmm.
Section, there is a judgment of this honorable court. My lord, I can just furnish, my lord. I'll furnish the copy, my lord. Assam temporarily settled lineage tenancy. Tenant dying intestate in respect of the right of tenancy is subject to a custom and so and so. Same manner, the right of the occupancy shall descend in the same manner as other immovable property. Tenancy right under Section Act of 97 include within the term any property under Section 15(2)(a) of the Hindu Succession Act.
Hmm.
So therefore, my lord, in my submission, it devolved on me by virtue of Section 7 as well as, my lord, the provision of Hindu
So,
Succession.
how succession take place in accordance with the Succession Act?
My lord, yeah. Now, my lord, there is Section 15 to Section 15. I will just. My lord, will Section 15. Section 15. First is section 8, I think, my lord, it will, section 8, my lord, may relevant in this
Section?
case. Section 8, my lord. General, because my lord, because the property was, my uncle was an occupancy tenant, my lord. So first he died. What will happen thereafter? Section, no, section 8, my lord, may kindly see.
Indian Succession Act.
My lord, Hindu Succession Act, lordship, not Indian succession. That is given, that is testimoniary succession. Hindu Succession Act 1956.
Hindu law doesn't know.
You talking here?
Yes.
My lordship will see, my lord. A general rule of succession in the case of male.
Mm.
The property of the male Hindu dying intestate shall devolve according to the provision of the chapter, firstly, upon the heirs being relative specified in class 1 of the schedule.
So here Jalandhar Roy left behind his wife,
Wife,
Sintamani.
Sintamani, my lord.
Yes.
Sintamani. Then, my lord,
So first,
Yeah.
she inherited the property.
yes, my lord, she inherited the property. As per lordship, kindly look into schedule 1.
Mm.
If I am a being, my lord, adopted this adopted by the my lord my uncle. So as per schedule 1, lordship will say, firstly upon the heirs being relatively specified in class 1, son, daughter, and widow, my lord. And the son means, my lord, as per the definition of adopted son also.
Mm.
Now, if
So
your
class
lordship
one were here, the wife
yes,
Sintamani
son,
has
daughter.
inherited the property.
Yes, my lord.
Okay.
Section 8. Section 8.
Thereafter,
My lord, they firstly upon the heirs being the relatively specified in class 1 of the schedule.
mm.
Now, how, my lord, the distribution will take place, that is governed by, my lord, section 11. Section 11.
So you are not the class one here. No, that
My lord, if
PW1 Nehru Roy is not the class one here.
my lord, class 1 here, in that sense, my lord, that since I have adopted by my uncle, my lord. So
No,
I am also coming with
to,
the class 1 here.
To show that you have been adopted by Jalandhar Roy.
Yes,
Where
my
is the evidence?
My lord, the evidence, my lord, because in my humble submission, not documentary evidence is required. Subject to your lordship, what my lord said.
No, where is the oral evidence?
No, my lord, in oral evidence also, my lord, if your lordship read into the evidence of PW and PW3 together, is established that in my humble subject to my lord's, because the after decision belongs to my lord.
PW1 we have already read.
Yes, now PW3 lordship may kindly
Yes.
see.
Lordship admitted fact not required to be proved. In the plaint also, he has made a mention and the affidavit was shown that Nirod Roy, son of late Novendra Chandra Roy. He has not stated that I am the son of Nirod. In the plaint, what was filed for the Senate trial court, he said Nirod Roy, son of late Novendra Chandra Roy, not stating the son of Nirod Roy. So his claim was structured on the basis of a fact that he is the son of Novendra Chandra Roy. If he is the son of Novendra Chandra Roy, then this is the admission of fact, and he is not the son of Jaladhar.
No, his contention is that he is adopted.
Exactly. If he was adopted, then instead of son of late Nogendra Chandra Roy, it should have been mentioned as son of Jalandhar
Jalandhar
Roy.
Roy.
Exactly. He has not narrated that fact because adoption came later on. So So at the time of institution of the suit, he should have mentioned the son of late Jalodhar Rao. He has mentioned son of late Nagendra Chandra Rao. That means it is a clear case of the fact that he has misplaced or misrepresented some material fact before the trial.
My lord, it's just a plain should be read as a whole, my lord.
No.
You know, plain should, no. So some one and two words pick up from here and there, my plain should read as a whole.
Okay,
That is a
let
certain law.
us see PW3.
Yes, my lord. I am a defendant number 3 to this suit. Defendant number 2 to 7 are my siblings. Because this PW3 is the, my lord, the successor interest of the person on whom my uncle, my lord, holding a tenancy right. He is deposing before this before the court, my lord, deposing before the court. I am the defendant number 3 to this suit. Defendant number 2 to 7 are my siblings. The suit land is covered by DAG number 108, so and so, suit land measured, so and so. I don't remember the other DAG number. The suit land is situated in Podgana, so and so. My father was the original owner of the suit land. My father has got ownership of the entire land under the suit patta by of a purchase in an auction. Jalodhar Rai was our riot. The Jalodhar Rai was the uncle of the plaintiff number 1, my lord. Jalodhar Rai was our riot occupancy tunnel. Jalodhar Rai had no issue. Nirodhar, the Nipu of the Jalodhar Rai, stayed with him, Jalodhar Rai. I don't remember the name of the Jalodhar Rai's wife. Jalodhar Rai was riot occupancy tenant on the homestead and agricultural land. After the death of Jalodhar Rai's wife, Chintamani Roy, Nirud Rai became the tenant. We acknowledge his tenancy. Nirod Rai has sold the jot right, interest of the suit land to plaintiff number 2, Ramkumar Roy. Exhibit 1 of the said sale deed under objection. Exhibit 1 and 4 are my signature. The objection as witness. Nirod Rai has been possessing the land and house since after the sale. Acknowledging Nirod Rai to be the occupancy tenant, I executed exhibit number 4, Shonnolipi, and exhibit 4 and 4.1 and 4.2 are my signature. I have been receiving the land from plaintiff Sri Ramkumar Roy regularly. We all the siblings mutually partition the property left by our father and have been possessing our respective shares. The suit land fall in share of my property. Defendant Sunamoni Roy is my sister. A title suit being so and so instituted in the court of ADJ 1 against the defendant number 2, Amala Roy. There is similarity between the suit line in that suit and that of this suit. Neither I nor my sibling were made parties to the earlier suit. Defendant number 1 and 2 fluently instituted that suit and secured the ex parte decree, so and so, my lord. Ex parte decree. Defendant number 2 is my sister, had never possessed the suit line of this suit. The suit line of this suit is bounded by so and so, so and so, so and so. My name has not been mutated in the part of the suit line. However, mutation stand in the name of Father Girish Namasudra. The mutation is reflected in the column number 12 of exhibit 3. I have no objection if the suit line is decreed in the favor of plaintiff number 2. Then, my lord, I do not know plaintiff number 1 sold if the right and interest suit line to the plaintiff number 2. However, after plaintiff number 1, plaintiff number 2 has been possessing the land about 10 to 12 years. I do not know whether any Khatiyan was received from the government. Jalodhar Rai was a tenant of my father, Girish Roy. Jalodhar Rai neither any of Joe settlement nor any Baina Rashid. He used to pay rent of ₹100 per year. So that is also established in the cross-examination. The Jalodhar Rai occupancy tenant paying the rent.
No, we are not concerned with that. We are concerned with this devolution of the property after the death of Chintamani Roy.
Now, my lord, then my lord will find he used to pay rent of 100 per year. Jalodhar Rai passed about 10-12 years ago. After Jalodhar Rai death, his wife Chintamani acquired the jot right and interest over the said land, and she used to pay rent to my father. Chintamani Roy passed away about 5-6 years ago. After Chintamani's death, plaintiff number 1 obtained the jot right and interest over the said land. There is no document or deed with regard to the Chintamani Nirod Rai according the jot right interest over the said land. I know Ram Kumar Rai, who has got this land from Nirod Rai and has been possessing it for 3-4 years. I do not know relation to Intamani and Joladhar, but Joladhar raised Nirod Rai in his house. Nirod was not related to the Joladhar Chintamani, but he used to live at the Joladhar house. Nirod Rai did not buy any property. I do not know how he got the said property.
So this line, this Nirud Roy was not related to Jalandhar or Sintamani,
Yes, my
but he used to
because
live
he,
at Jalandhar's
my lord,
house.
my lord, my
Had
yes.
Nirud Roy been adopted,
Ah.
this witness would have deposed that he is adopted son. Where is the averment?
My lord, this.
Where is the deposition?
My lord, the evidence rate is in my humble sense on the technicalities, my lord. It established that he has been raised by his uncle.
Maybe.
Since my lord, long years. My lord.
Raising
years, my lord.
Raising a
And my
person
lord,
does
when
not
the
mean that
adoption
he
was-
was adopted.
Yes, my lord. When my lord adoption, generally my lord adoption, there is a age limit of adoption, my lord. So when adoption takes place, my lord, he was a minor. He was a minor.
Where is that evidence? At that time he was minor.
My lord will kindly see now, my lord. Again, I will take my lord to the Hindu Adoption and Minority Act, my lord. Lordship may kindly see. Lordship will kindly see.
Adoption Act. You can test it. Oh.
Yes, the Lord will see, my lord, the person capable of giving in adoption. Then, my lord, section 10, person who may be adopted. No person shall capable of being taken a adoption unless following she or he is a Hindu, or she has not been already adopted, he or she has not been married, unless there is a custom and others applicable to the parties which permits person who are the married being taken in the adoption, he or she has not completed the age of 15 years. So, my lord, when it was taken place, he was a minor, my lord.
Where is the evidence? All right. Your contention is that he was minor.
Yes, my lord.
You show me the evidence that he was minor at that point of time. Your mere submission will not do.
Affidavit এইটো বয়স কত আছে এফিডেভিটে বয়স কত আছে এফিডেভিট এফিডেভিট না এটাইলে লাগতে লাগতে দিলে হয়ে যাবে But my lord, the suit was filed in 96 months, and Joladhar Rai, my lord, his uncle died, my lord, in the year 1984, my lord. 77, 78, my lord. And the suit was filed in 1996, my lord. Now, 18 years back, my lord. And the adoption took place,
No,
my lord.
that's all right.
Even before that, my lord. So we can calculate the age, my lord, not with the precise calculation, but hypothetically.
Unless it is deposed
My lord.
by the witnesses and also it is averred in the plaint.
Yes.
Can we accept such a submission? we cannot deliver the judgment on surmise.
And that I know, my lord, that
Then?
that I know, my lord, that I know, lordship. Now, because his suit was filed in 1996, my lord, first.
Hmm.
So, my lord, 1996, my lord, Jolodhar Rai died in 77, 78. I am just chronologically trying to, my lord, correlate, my lord. So, he died 18 years before filing of the suit, my lord. And the adoption, whether it is acceptable or not, that's a different issue, my lord. But the fact of that was, my lord, even before that. Because a person cannot be beyond 15 years if you adopted, my lord.
Hmm. Hmm.
So I don't have, my lord, now I am not getting a copy of the affidavit, my lord. And so otherwise, my lord, I could have just submit before my
Better you
date of the death of the
let us adjourn the case. You go through that affidavit.
lordship.
Where it is.
Yes, my lord.
Then the plain lordship, the lawful record is there, lordship.
Hmm.
In the lawful record, you can go through the age in the plain, from the copy of the plain. You get the age.
Okay, you go through the record then. You come prepared on next date.
My lord, my lord.
Pardon?
2013 matter, lordship, not 2020.
No, what to do? If you are not prepared to argue the matter, then
Otherwise, lordship, on the very initial stage, I made a mention because he is making the submission on behalf of the person, the plaintiff number one. But the plaintiff number one is not has not assailed this particular order for this honor. So
Hmm.
whether he can argue his point when the plaintiff number one is not there, he has accepted the proposition.
maybe let him argue.
My lord, order for
We'll see whether we can.
Yeah.
But you cannot take the plea
yes,
of the
yes.
appellant number one.
Order 4105, any
You
of the
take the
defendant
plea
or
of the
plaintiff,
plaintiff
my lord,
number
yeah. Because
Because
commonly a common
plaintiff
cause of
number
action.
one accepted the proposition. That's why he has not come for this honor. Now the plaintiff number two is fighting the battle without having any suit.
Order 4104, my lord. I'll submit on that, my lord. My
Order
lord, one of
41?
the several plaintiff defendant may obtain reversal of the whole decree where it is proceeded on a ground common to all. So this is one of the because
I'm not on there. I'm not on there, but I'm submitting before this honor.
he said, my lord, I did not file the preferred the appeal, so my I am stopped.
Not you, the plaintiff number one.
Plaintiff number one, so I am stopped. So
Exactly.
the plaintiff number two cannot file.
This particular issue
Plaintiff number two
substantially
cannot take the my lord the step in the suit of plaintiff number one. Yes.
If the
Why
plaintiff
not?
number one is not agitating the issue, because all these facts are within the knowledge of the plaintiff number one, not within the knowledge of the plaintiff number. You cannot read all this.
Yes, he has deposed, my lord, that is within his knowledge. It is within his knowledge. He has deposed.
That's why he has not come before the court. But that is again finality. If I say that this particular aspect of the matter he is assailing, that's a different issue. He is not assailing that order. The plaintiff number
Okay,
one is not assailing that order.
let him go through the record. Let him satisfy this court. Heard Mr. Vijay Ghosh, Lorded Counsel for the appellant. Mr. S.P. Soduri for the respondent. Heard in part, list the matter as part heard on. Court of August.
My lord, make fixed on 6th August, my lord.
6 of August.
Lord,
All right, no problem.
My lord, oblige. Oblige.
Okay.
This appeal is by the appellant who was at the first instance, the defendants. And my lord, thereafter filed first appeal and on dismissal thereof, my lord, before your lordship, my lord. The initial decree, your lordship will find at 40 page 47, my lord.
Yes. Initial decree means,
My lord, at this suit, my lord, suit was decreed against me, my lord.
Hmm.
This was a suit for declaration of joint right, title and interest over a schedule of the plaintiffs, defendants and pro forma defendants. Out of the said land, the plaintiffs are entitled to 2 biga 4 kata 11 lecha, etc., my lord. Then this order, this decree was, my lord, this order was passed. I'm just reading out page 47, man. May I? The suit land being revenue paying estate, therefore a preliminary decree for partition be passed of the schedule B land of the plaintiff. Let the preliminary decree be sent to the collector of Porpeta for effecting the partition in accordance with the Assam Land and Revenue Regulation. The collector, after effecting the partition between the parties, shall submit the partition paper before this court for drawing up the final decree. Thus, these issues are decided affirmative and in favor of the plaintiffs. Order. The plaintiffs have been able to prove its case. As a result, the plaintiff suit is decreed on contest with cost, declaring that the, as your lordship got in page 47.
got it.
47.
But I am looking the substantial question of law.
Substantial question, your lordship, the page number, my lord. 6,
There is
my
only
lord,
one
dated
substantial question of law.
6/12/2019, my lord. That is the order.
Mhm.
Order 6/12/2019. Whether the suit of the respondent plaintiffs being hit by the principles of res judicata inasmuch as the petition filed by the plaintiffs in their earlier suit, title suit number so and so, against the appellants defendants was answered by the learned court below only to the extent of allowing to withdraw the suit without any specific order of granting liberty, which led to the perversity of the findings of the learned courts below. So this was, my lord, this was also discussed, my lord, I have found. They made 2 prayers. Also, my lord, they prayed for a liberty. That liberty was, there is no specific, my lord, order so far as liberty is concerned.
Liberty was not granted.
Not granted.
But whether that suit was decided on merit,
No, it was not, it was withdrawn, my lord,
withdrawn.
by the plaintiffs with a prayer for liberty to come again, my lord, come back again, to file a fresh suit. Now,
But
the second
liberty
part
was not granted.
second part was not granted.
Where is that order?
It is there, my lord. My lord, page 37, my lord. Page 36 is the application filed by the plaintiff,
Hmm.
and page 37 is the order. Both parties represented by their learned counsels in the petition number so and so citing a withdrawal to which is allowed. According instance stands, suit stands disposed of on withdrawal.
Whether the res judicator principle will be applicable in this case.
That is the, my lord, taken up by the defendants, my lord.
During trial.
Well, my lord, they did not touch, my lord, the learned court below did not touch on the that liberty that was sought for, my lord. Didn't say anything about it.
Whether such a plea was taken during trial regarding res judicator.
Trial, my lord, no. In the appeal at stage, I think it was taken. First appeal stage.
Appellate stage.
No.
What is the memo of appeal? Before the
Annexer 6, page 87.
87.
Title appeal number 062019.
'87 is the judgment of the
My
appellate
lord,
court.
this is a judgment, man.
Memo of appeal.
Memo of appeal. Huh? Not a part of the paper.
So we'll see the,
Yes, I have to wait. Need to file, I don't know, file as a late fee. Memo appeal আছে নি?
না।
ওটা আছে, কিন্তু ফাইলটা এইটু বুঝেই না।
trial court, no, appellate court or record. So copy is with you.
My lord,
That-
the copy is with me, my lord. I am strictly sorry, my lord. The connected file lower court record was left out, my lord, inadvertently. That is with me.
No, my question is, whether the plea of res judicata is taken before the first appellate court.
My lord,
Because
from
in
the,
second appeal,
from
in
page
second
9
appeal
from page 93, my lord.
of the judgment.
Yes, my lord, it can be, it was, it must have been there, my lord. And I am extremely sorry, my lord, that file
Page
was,
number 80,
my lord,
page number
page 93,
90.
para 18.
Yes.
May I read, my lord? During the course of argument, the learned counsel appearing for the respondent plaintiff contended that in the order dated 28/6/2006, though the learned Muslim number 1 Borpeta did not specifically mention that plaintiff has been allowed to withdraw the suit with liberty to file a fresh suit, but it means that the court allowed the plaintiff to withdraw the suit with liberty to file fresh suit as there is specific prayer in the petition. While allowing the withdrawal of the suit, court allows the entire prayer of the petition as a whole, but the learned counsel of the appellant's defendants, by referring to a decision of the judgment of Allahabad High Court reported in AR 1973 Allahabad so and so, contends that if no specific order is passed, it is not permissible to enforce such an order by constructive interpretation. Where two reliefs are prayed for, a court specifically grants one relief. The only inference that can be drawn is that the other relief has been refused. But the learned Munsif, after hearing both sides, allowed the prayer of the plaintiff based on decisions of the Honorable Supreme Court reported in 207 so and so so and so, wherein the Honorable Supreme Court held that in the case of an application to withdraw a suit in terms of Order 23, Rule 1 to CPC, the court allowed the suit to be withdrawn but refuses permission to bring a fresh suit. The court's order is erroneous. Because of the trial court, because if the trial court saw no reason for allowing the withdrawal in terms of Order 23, Rule 1 to CPC, the trial court should the trial court should have refused the application seeking liberty to file a fresh suit, and it should have proceeded with the suit on merit. The learned counsel for the respondent plaintiffs vehemently contend that the same judgment referred to above has also been reported in AR so and so so and so. It was division bench judgment of the Honorable Apex Court consisting of Dr. So and so and Kapadia JJ, which is still holding the field. In the said judgment in paragraph 19, it was held as under. Then quoting para 19, in view of the above judgment, the position in law is clear that when the court allows the suit to be withdrawn without liberty to file a fresh suit, without any adjudication, such order allowing withdrawal cannot constitute a decree, and it cannot debar the petitioners herein from taking the defense in the second round of litigation as held in the impugned judgment. The above judgments indicate that if a plaintiff withdraws the suit, the order of the court allowing such withdrawal does not constitute a decree under section 2 of the code, that in any event it will not preclude the petitioners herein, defendants in second round, from raising the plea that the sale deed executed by Chelia Nadar on 26/7 in favor of the Nadar was not true and valid. Thus, the civil appeal needs to be allowed. In the above judgment, the Honorable Supreme Court clearly held that if the plaintiff withdraws the suit, the order of court allowing such withdrawal does not constitute a decree under section 2.2 of the code. That in any event, it will not preclude the petitioners herein, defendants in second round, from arising the plea that the sale deed executed by Shelia Nadar on 26/2/73 in favor of Thangaraz Nadar was not true and valid. Coming back to the instant case, while allowing the withdrawal, learned Munsif number 1, Borpeta in so and so passed the following order dated. Both parties are represented by their learned counsel. In the petition number 81506 citing reason for withdrawal of the suit which is allowed. Accordingly, the instant suit stands disposed of on withdrawal. In the petition number 81506 filed under order 23 rule 1, it was specifically prayed that due to some formal defect and some necessary parties are required to be included in the suit. Therefore, it was prayed that plaintiffs be permitted to withdraw the suit with the liberty to file a fresh suit on the same cause of action. Therefore, the order dated 28/6/2006 is not a decree under section 2 of subsection 2 of CPC, as it is not a final adjudication. In view of this is the finding, man. In view of the judgment of the Honorable Apex Court, this court is of considered view that the argument advanced by the learned lawyer of the appellants defendants has little force as the order dated so and so of the learned Munsif in title suit number does not prevent the plaintiffs respondents from instituting a fresh suit on the same cause of action. As such, the court do not find any infirmity in the finding of the learned trial court in additional issue number A. So this is a minor, this was the finding minor. Then
So
there is
before the trial court, no such issue was taken
minor
before the trial court.
trial court minor.
In the appellate court also, it was the submission of the conducting counsel for the respondent.
Minor.
But is it there in the memo of appeal?
That I can place, my lord,
One second, my lord, taking here, my lord, to one appeal. It was filed before the present appeal. That is title appeal 2006 of 9 of 2011. The original case was decreed by order dated 9/12/2010. Subsequently, the defendant present appellant approached the first appellate court by filing a title appeal that is 9 of 2011. In the said appeal, the case was remanded back for directed to settle additional issues.
Additional issues.
Additional issue means that that was already decided
By the trial
by
court.
the trial court.
My lord.
Okay.
As such, this is not the substantial issues of law, it is already settled. And two issues are left in the first
No,
appellate
it
court.
may be a substantial question of law if the trial court, if there is perversity
Yes,
in deciding that issue.
yes, but there is not that perversity. Subsequently, my lord, that first appeal in the first appellate court decided by and subsequently again after disposal of the title suit second time, they again approached the first appellate court by filing title appeal 6 of 2019, which was disposed of 27/2019. Very different is there. 100 different.
Okay. So, Mr. Goswami,
My lord.
you say the first appellate court, when the impugned judgment
My lord.
has relied upon a decision of Supreme Court.
Yes, madam.
That is
That is also mentioned.
207
My lord.
AIAR Civil, page number 398.
My lord.
So after discussion of the decision of the Supreme Court and
That
also
finding
the
was-
evidence, appellate court arrive at the finding
Yes, my lord.
that the res educata is not a bar.
My lord.
So how this finding is illegal or arbitrary? Because this is the substantial question of law.
My lord. My lord, there is another issue, my lord. At page, at para 29, page 96, my lord.
What is the issue?
My lord, there is a, in the schedule, my lord, there is also a part of annual pata land, my lord.
Well, maybe, but Mr. Goswami, you see, in second appeal, we have to confine ourselves
My lord.
only in the
questions of
substantial
law.
question of law.
Law, my lord.
So
I'm coming to that, my lord.
yes.
I'll just read out this para 29 for a
Hmm.
page 96, my lord.
Yes.
The defendants in order, has your lordship, defendants order to establish the fact that they have right, title, and interest over the Schedule C land, have exhibited certified copy of Shitha of annual dark number Iman as Exhibit B, and the plaintiffs have exhibited the same document as Exhibit 3. On perusal of Exhibit 3 and Exhibit B, which are the same document, shows that the name of defendant number 1 has been mutated over the said land as sharer along with the names of the plaintiffs over 2 Katha 10 lesser of land, but it is confirmed by PW1 as well as by DW2 Siddiqur Rahman that he is not a sharer with Afaz Sheikh. Afaz Sheikh is the original landlord. DW1 further stated that he has mutated his name over the land measuring 2 Katha 10 lesser covered by Dag number 634 on the basis of sale deed. But he could not submit the sale deed. DW1 Azmol Ali in his cross-examination stated that the defendant have no other land in the suit pata except the land purchased from Moyes Sega, an original minor pata. Therefore, court comes to the finding that defendants have no right, title, and interest over the Schedule C land of the plaintiff, though the name of the defendant number 1 was mutated over Schedule C land, but failed to prove this claim by any documentary evidence. But plaintiffs have been able to establish the fact that they have right. But I'm extremely sorry, my lord. It relates to my lord DW, my lord. Actually, they had mentioned, my lord, sale deed, my lord. My submission was an annual pata land. There cannot be any sale deed, my lord. But it is the defense witness they have mentioned. I just overlooked, my lord. They have mentioned, my lord, that sale deed, your lordship has seen Dag number 630 on the basis of sale deed, but he could not submit the sale deed. Well, annual, in any case, my lord, annual pata land, my lord, Exonia pata, how can they file sale deed, my lord? But this was from the defendant side. Oh, I'm sorry. Then, my lord, lastly, my lord, I would like to point out one other thing, my lord. Your lordship in mixed questions of facts and law, my lord. My lord, if your lordship kindly comes to their plaint, my lord, what they have stated. Because the suit is for partition, my lord, they have preliminary decree is for partition, my lord. Your lordship will kindly come to page 12 and 11, my lord. 11 and 12.
Yes.
11 and 12, my lord. Now, here they refer to a Dag, my lord, 635. Dag number 635, page 11. About fifth line, said, first 1, 2, 3, 4, 5. Said Abdul Ghaffar sold his 2 bighas of land in favor of Rustom Ali, and Rustom Ali possessed 2 bighas of land. Rustom Ali is my predecessor from land from Dag number 635 of A schedule land, and after his death, the main defendants possessed the said 2 bighas of land. Therefore, the revenue authority mutated the name so and so. My lord, this Dag 635, second, and then again reference to the Dag 635, my lord. a schedule land of the plain. Then page 12, what I want to point out, my lord. Page 12. But this will be 1, 2, 3, 4, 5, 6, 7, 8, my lord, line 8. The plaintiff's number to purchase 2 katha 10 lesa of land from Afazuddin, Dag number 635 under Pata number 195 of village Bonbahar. Your lordship will kindly note. Village Bonbahar. Plaintiffs number 2, 3, and 4 purchase 1 bigha of land from Majibo River, said Dags and Patas, that is Bonbahar. The plaintiff number 2 purchased 1 katha 5 lesa of land from Siddiq Ali. Therefore, the plaintiffs have got rightful interest over so and so of land covered by Dag number 635 under Pata number 195 of village Bonbahar. Now, my lord, if your lordship comes to, my lord, the schedule. Page 17, my lord. Schedule A is the land, my lord, where 635 is referred. And Schedule B also, my lord. Schedule A, plaintiffs, defendants, and pro forma defendants have joint rights, title, and interest. 5 bigha, 2 katha, 8 lesa of land covered by Dag number 635 and so and so, so and so, so and so, covered by periodic Patna of village Rampur. Here the village name is different. And Schedule B, where the plaintiffs claim to have right, title, and interest. 2 bigha, 4 katha, 11 lesa of land out of so and so, so and so, so and so, Dag number 635 again. And 1 bigha, 0 katha, 16 lesa covered by Dag number 9 under Pata number 195 of village Rampur. Here, my lord, there is no reference to, my lord, any Bonbahar village, my lord, 635. How will the decree for partition, my lord, will be carried out? Where is that village?
That's all right, but whether such an issue was taken? Whether any issue was framed by the trial court?
Boundaries are also, my lord, the
Maybe.
annual Pata land, there is no boundary given in Schedule C. Your lordship will see page 18. 1 bigha, 1 katha, 0 lesa of land covered by annual Dag. Annual Pata, it should be actually. Number 634 of Obung. There is no boundary, my lord. How will this decree can be carried out? This is a preliminary decree for partition, my lord.
No, that's all right, but
There will be
unless you have taken such a plea before the first appellate court, you cannot raise the plea before this court. And
That
moreover,
is-
no substantial
I don't
question of
agree- I
law is
agree with
framed in
your
this point.
lordship, my lord. It is only with the liberty that was
If you want to pursue
only, my lord, yes, my lord, only with
this
the,
issue, then we have to frame one substantial question of law.
my
And
lord.
then again, we have to examine whether such plea was taken in the first appellate court or not.
Yes, ma'am.
And the memo of appeal is not available with you.
Well, a memo of appeal, I can place, my lord, I'm extremely sorry, my lord, that the file that was,
No, that is available with the court because the trial court record is available.
my lord.
But if I put any question, you would not be able to answer the same today because the copy is not available with you.
In my file, my lord, that lower court records,
So you come prepared then.
my lord,
We'll adjourn the matter.
my lord.
Heard, Mr. Rusami, learned counsel for the appellant. Any other? Appeal record nahi hai. Appeal record nahi.
Appeal for the file, sir, I should have to do. Report is very related.
That's my record, sir. That plea was not taken in the appellate court.
Not taken. Heard, Mr. Rusami, learned counsel for the appellant. And Mr.
K.U. Ahmed.
K.U. Ahmed, learned counsel for the respondent. Heard in part, list
Heard,
the
yes.
matter.
Third department. Third
After?
department.
After? 1 week
After
or 2 weeks?
15th of August, my lord, in any case, my lord.
After 15th of August. Kabir?
18th,
Not 18, my lord. My much obliged, madam.
Lordship, kindly the matter may be taken up after Sunday's Lordship,
After?
after 1 week or 2 weeks.
Is it a part-heard matter before any other court?
Lordship?
Is it a part-heard matter before any other court?
No, not part
No,
of
no.
it.
Time to pass code is.
Next week of date to relative day.
No, no.
Heard Ms. Saha, learned counsel for the appellate. And Mr. Orhuya,
Yes, respondent number one,
learned counsel
Lordship.
for the respondent number,
1.
respondent number 1. Ms. Saha, praise for listing the matter after 1 week.
Next,
Fair allowed?
no, Lordship, urgency, because they are forcefully evicting me. This is my case, concurrent findings there. Within a week, Lordship, date may be given. On
6th of
10th,
August.
Lordship,
6th August. Okay.
6th August.
Okay.
Much
Obliged.